And we are still in license law and commission rule. A few more things to get through in this little section. So we're going to pick up where we left off. Specifically, we are on page 719 in your book. Good morning. And we are in the throes of talking about general brokerage provisions. And talking about general brokerage provisions, where we left off is talking about brokers as parties to the transaction. So real estate agents buy. A question came in when we do a little review. You have the review. Remember that PowerPoint, your exam review PowerPoint? So it's in Learn, Test, Pass, and I'll show you where that is in just a bit. So brokers as parties to the transaction. You very well may buy or sell your own real estate, your own personal property. And first off, like remember what we said last week, you as a party to the transaction, you're now held to a higher standard. So when you're selling your own home or when you're purchasing a home, not only are you the buyer or the seller, but now you're also the licensed real estate agent that knows better than the party on the other side, right? So you're going to be held to a higher standard. Everybody good with me so far on that? Once you're licensed, the commission now knows that you know, okay? And you're still dealing with the general public. Specifically, if you are selling your own property, you cannot represent the buyer in that transaction. Let's talk this through. I'm the seller and the listing agent. To fairly represent a buyer, to have a buyer client, whose best interest should I have? I should have theirs. They're my buyer client. But the truth is I'm the owner of record. So whose best interest do I actually have? Mine all day long, right? Can everybody see the huge conflict of interest with this? I cannot fairly represent. I can list my own home for sale. If a buyer, unrepresented buyer comes in and says, I want representation, I can let somebody else in my firm work with them, but I can't. As with most rules, there are exceptions. And the exception to this rule is if you own commercial property, if you have less than a 25% interest. If you have less than a 25% interest in commercial property, you can represent the buyer in the transaction as long as you give them full disclosure. You tell them ahead of time, I own 23 1/3%, da 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 da. Do you still want me, everybody with me? You still want me to represent commercial properties only? So general brokerage provision covers us as part of the transactions. Devin, let me check on you. Can you hear me now? You all set? Cool, cool. Another general brokerage provision addresses if you change your name or your address. When you change any of your contact information, the real estate commission says we need to notify them of that change within 10 days. Once you guys get licensed, you will have a log on the North Carolina Real Estate Commission's website. And you can log on and access your files, access your records, check your CE, check your post licensing. We'll talk about CE and post in just a second. You can also change your information. So if you get married or divorced and change your name, if you move, you can update your information within 10 days. There's general brokerage provisions on advertising. This first one we should be good with. I cannot perform a single service for an owner until I have a written agency agreement. So I have to have written consent. Within our agency agreement is consent to advertise for sale or for rent. Am I going to put a sign in the front yard, lockbox on the property? The broker in charge of each office is responsible for the advertising that comes from that office. So if you're promoting a listing for sale, if you're promoting your brokerage services, the BIC is ultimately responsible for the advertising. The BIC should review it periodically, especially with you guys as soon to be provisional brokers. Before you put anything, y'all know what happens on the internet when you hit submit? You know where it goes? Everywhere. If you ever tried to get something back, it's really hard to do. So don't submit and then have your BIC review it. You have them review it before you publish. And yes, this does apply to social media, print media, etc. So BIC should be reviewing. BIC's looking for several things. They want to make sure there's no unintentional discriminatory language. They want to make sure that you match your firm's identity. So your firm has a branding, right? What you guys look at Golden Arches and you see McDonald's. That's McDonald's brand identity. That's their firm identity. And your firm will have their identity. They got a logo and specific colors that you can use. So just an example of things that the BIC should be looking for. The other rule with advertising pertains to blind ads. And a blind ad is one that does not identify the name of the firm. Remember, whose listing is it? It's the firm. So if I say Julie Campbell has a home for sale, that's a blind ad, right? Because I don't say Julie Campbell of XYZ Real Estate. Everybody with me? It's the firm's listing, not yours. So you need to make sure, and this does include social media. And I'm guaranteed we could all log on to Facebook right now and find a real estate agent that doesn't do this right. So does that make it right? Nah, not at all. Because what does general brokerage provision say? We have to include the firm's name. Again, they'll talk to you about your advertising. So no blind ads, print or social media. Another general brokerage provision addresses the delivery of instruments. Let's first talk about what the heck an instrument is. An instrument is just any document related to this transaction. So typically it starts with our agency agreements, working with buyer, seller, we get a signed agency agreement, working with real estate agent disclosure. At some point, fingers crossed, hopefully it moves on to a contract where I have a signed contract with addenda and amendments. And then fingers crossed, the last stage would be closing, where we have closing documents. This rule says that we have to deliver instruments to the consumer within 3 days of execution, within 3 days of them signing the form. There's a common misconception out there. Some agents think I'll just wait until the end of the transaction and send them everything. But what does general brokerage provision say? We have to deliver the instruments within 3 days of them signing. So they sign the agency agreement. You send them an email with a PDF attachment talking about, here's our signed agency agreement. I look forward to working with you. We go under contract. You send them an email with a PDF attachment. General rule of thumb, if they sign it, they deserve a copy of it. Please note, this rule says that my job is to deliver it. Do I have anything to do with what they do with it when they receive it? That's not my job, is it? My job is to deliver it. And let me ask you guys, y'all do your head one way or another. Are you gonna keep documentation that you sent it? Yeah, because what do we document? Everything. So once you send an email with a PDF attachment, go into your sent files and flag it for that transaction. So you have a date and time stamp that you sent that email with the PDF attachment. If you want to hand deliver it, there's no wrong way to deliver it. I just think the most simplest thing for us to do is send an email with PDF attachment. What's the exception to this rule? The exception to this rule refers back to delivering offers to our sellers, delivering offers to sellers. And that rule says we deliver all offers when immediately, but in no event later than 3 days. So we deliver offers to our sellers. Don't sit on them for 3 days. We deliver offers to our sellers immediately, but in no event later than 3 days. And I got to tell you, you better have a pretty good excuse to sit on a seller's offer for 3 days. Again, how long does it take you to send an email with a PDF attachment? Call your seller. Hey, we got an offer. That's exciting stuff. Next general brokerage provision we've talked about. Show me on your hands. How many years do we retain records? How many years do we keep records? We keep everything. Good job, guys. We keep everything for 3 years. We're documenting everything. So if we document everything, what do you think we keep? Everything. And you keep it for how long? 3 years from the successful or unsuccessful conclusion of the transaction. Your 3-year clock starts when the transaction ends. Maybe it closes, maybe it doesn't. But your 3-year clock starts whenever it ends, whenever you're completely finished with the transaction. Obviously, we're going to keep our agency agreements, contract paperwork, closing paperwork. We're going to keep emails. We're going to keep text, notes on a napkin that pertain to this transaction. Advertising. You guys need to keep note of your advertising, even if it's just a screenshot of your Facebook when you promote a listing, right? You need to keep your advertising for 3 years. If you measure your own listing, you need to keep your measurement sketches and notes for 3 years. Document everything and keep it all. When it comes to our fee and compensation, if we're going to make money from another party, we need to disclose that to our principal, and we have to give them full and timely disclosure. Let's say, for example, I'm the buyer's agent, I'm working with a buyer, and the builder is offering me a $500 bonus. I have got to disclose to my buyer client that I'm getting that $500. In other words, if you buy this house, I'm going to make more money. I'm going to make $500. And we have to do it in full and timely disclosure. That does not mean sitting at the closing table. That means when your buyer's deciding if they want to present an offer, if they want to make an offer on that property, they need to take that into consideration. Let's break this down for a second. Seller pays commission off the sales price. Yes? Everybody good? Seller pays commission off the sales price. Who pays the sales price? The buyer. So technically, who's paying for that $500 bonus? The buyer, because you think the builder rolled that into their sales price? You guys follow my logic here? So why does the buyer need to know? Because it's affecting them. They need to take that into consideration. There are some restrictions when it comes to disclosing. For example, it is nobody's business what my split is with my firm. Remember our commission tree? The firm gets paid and then they share their commission with the agent. It is nobody's business how much I make. The only thing we advertise, the only thing we promote is how much the firm makes. So we don't have to disclose our actual split. And we don't have to disclose our commission to customers. It's only the client. And the real estate commission does not get involved with your commission. The real estate commission doesn't get involved with matters of money. If you're not happy with the commission split you're receiving from your firm, find a new firm. Do not call the real estate commission. They're not going to help you. They don't get involved with matters of money. As we've mentioned, There's rules and regulations on compensating unlicensed employees. Unlicensed employees cannot receive referral fees, commission from the purchase or from the sale of the transaction. Unlicensed persons are paid hourly or salary. They're not paid on a per transaction basis. And then all of our fees, kickbacks, referral fees, anything like that. Remember, if RESPA is involved, we cannot get a referral fee or kickback for recommending services. Do your head one way or another. Is RESPA involved in every single real estate transaction, sales transaction? Are they involved in all of them? No, remember RESPA is a lender law. So if it's a cash buyer, you don't have lenders. If you don't have lenders, you don't have RESPA, you don't have TRID. RESPA does not have any regulations or restrictions on agent to agent referral fees, for example. We talked a little bit last week about the broker in charge. We're going to talk a little bit more about the broker in charge on page, bottom of page 721. Remember, every single office location has to have a designated broker in charge. You need one BIC under each roof. The BIC can only supervise one office. You can't have a BIC supervising multiple offices. To be the designated broker in charge, you first have to become BIC eligible. We talked about that last week. To become BIC eligible, you have to have experience. You have to take the BIC course. You have to have an active license, non-provisional status. Once you're BIC eligible, then you can become the designated broker in charge. At some point, you guys may want to start your own firm. You may want to open your own doors. And you have choices. You don't have to become the broker in charge of your own firm. You could open your own firm as a sole proprietor. So the question is, as a sole proprietor, do I have to become the designated broker in charge, or do I have to have a designated broker in charge? As a sole proprietor, you only need a BIC if you plan to maintain a trust account. We're going to talk about the trust account in just a second. If you're going to advertise your brokerage services in any way, hand out a business card, or if you have brokers affiliated with you. You can only be a sole proprietor if you don't have these three things. If you want to do any of these, you have to either make yourself the designated broker in charge or bring somebody on board that can be the designated BIC. So not all sole proprietors have a BIC. Understand then, a sole proprietor is pretty much receiving referrals from family and friends, right? Because you're not advertising your services. You're not out there promoting yourself. So the business you get is from those that should reasonably know that you have a license. And who reasonably knows you have a license? Mom, dad, significant other. This is the second piece of my retirement plan. When I get to that point, sole proprietor, hand my book of business over to some young agent in my firm. Here you go. And then I just sit back and collect referral fees. That's my plan. Doesn't that sound nice? Somebody says like word of mouth. Nope, I can't even do word of mouth. It is, like I said, it's family, it's friends, it's those that should reasonably know that I have a license. Usually what I'm going to do is refer them out. I can't take a listing because then I have a yard sign with my name on it advertising my services. So I would have to refer out listings. The only one I could work with then is buyers if I choose to. There's other questions like, am I a member of MLS? Do I have access to the property, to the information? If not, I may need to refer them and just collect a referral fee. So again, you guys have choices, and you know, you're a couple years away, I understand. But if opening your own firm is something you want to do, then you guys need to look into this, make sure the laws and rules haven't changed from today. But a sole proprietor may or may not need a BIC, a designated BIC. Do I have any questions on this? Question comes in, can a broker in another state with more than 2-year full-time experience become a BIC? They can't. I'm not sure if they have, because it depends on, I would think it depends on the experience. Would think it depends on the state too, because some states aren't reciprocal with North Carolina, like Florida. They march to a totally different drum than what we do here. So I'm going to say the answer to that question is it depends. Eventually, sure, you can, but if you're asking right away, I'm going to say it depends. Okay. We saw this last week. To become BIC eligible, you have to have an active license. Non-provisional status makes sense. You have to have some experience. And then you got this 12-hour BIC course. So can a broker in another state with more than 2 years become a BIC? I mean, at the least, at the very minimum, they'd have to do this 12-hour BIC course before they could get that designation. Question comes in, if it's a sole proprietor, does it need a firm license? Does this apply if there's a BIC with a sole proprietor? No, once you get it, then now you're a firm. So then you would have to have a firm license. Yep. So they're required, and again, once you're BIC eligible, you're in a position to become the designated broker in charge. 2-year time clock start. Yep. Once you get licensed, whenever you start your business. I think I told you guys last week that I became BIC eligible in 2020 during the pandemic, and they just asked me, where have you worked in the last 5 years? They didn't ask for my actual experience, production, but they did want to see that I was affiliated with a firm for the last. So if you get your license and you don't affiliate, they would consider that not as experience. Once you affiliate, though. Again, you guys, you're ways away from becoming a BIC. You still got some ways to go. And again, you're going to look when you're ready for this. But give you something to look forward to. Nope, just 2 years experience. Yep, just experience. Even as a provisional broker, you're still out there getting experience, assuming that you're affiliated with a firm, right? That's the key. Just because you're a PB doesn't mean you're getting experience. Can I draft legal documents? Do your head one way or the other. Can we draft? I wish I saw more head shaking no right now. Let me ask this again. Can we draft legally binding documents? Still can't get all the heads to shake. No, we cannot draft. You guys, please listen to me. Agents get themselves in trouble with this because they think they're helping. Y'all want to know the truth? I'm a heck of a lot cheaper than an attorney. You're going to get asked all the time, can't you do this? Can't you add this provision? Can't you do this? You're going to get asked this all the time. You guys tell me you want a real world scenario. Buyers and sellers are going to ask you to do these things. And even though they're your client and they're asking you to do them, can we? No, only attorneys can draft legally binding documents. What am I allowed to do? It's so simple. I'm allowed to fill in the blanks. They provide me with pre-printed forms and I fill in the blanks. Attorney's draft, attorneys offer title opinion, attorneys tell parties how to take title. We cannot act like attorneys. Question comes in or comment comes in, the parties to the transaction can draft, but just because they can, does that mean that they should? No, we should always recommend that they seek counsel from an attorney. They don't know the legal effects. They don't know the legal ramifications of their drafting. So when your buyers or sellers want to whip out their red pen and start drafting, highly advise them, highly recommend them to seek counsel from an attorney. That's right. Agency agreements are not sales contracts. Who's the agency agreement between? The client and who? The firm. So the firm is a party to the transaction, right? Sales contracts are between buyer and seller. I'm the third party in a sales contract. Does everybody understand that? I feel like I should say that again. I am the third party in a sales contract. General brokerage provisions on our sales contracts. Remember, we have pre-printed forms that we're allowed to use. So any minimum terms have to be in the sales contract. This is the problem topic. This is what I need you guys to hear me say. I can use any other pre-printed form. I don't have to use the standard forms provided to me by the North Carolina Real Estate Commission. I'm sorry, by the North Carolina Association of Realtors. Forms come from NCAR. I can use any pre-printed form. I can use any attorney drafted form. It's got to match this rule. Now, you don't need to know the rule. You don't need to know the number. All you need to know right now is there's a rule out there that says, as long as the contract is drafted by an attorney and meets these minimum terms, the licensee can use it. So my question to you is, can I use any pre-printed sales contract drafted by an attorney? As long as it meets these rules. You guys, do you know how common it is for a builder to have their own forms? It's very common for the builder to have their own sales contract. What questions do I have on that?
I have a question.
Yes.
Which forms would you recommend, like for most people?
NCAR,
Okay.
whatever's provided to me. Yep. So if I'm working with a buyer that's going new construction, we're going to do what the builder wants us to do, right? But if it's buyer and seller resale, I mean, they've already created the wheel for you guys. That's what they did with these pre-printed forms. They created the wheel. Unless you have a unique situation, something like that, then you, or in a builder, you know, something like that. Question comes in, do you have to be members of NCAR to use their forms? Yes. So once you join the local board of realtors, that gets you into NCAR, and that also gets you into NAR. So you affiliate with a firm, join your local association, and you're going to get all sorts of good information. Other questions on this? All right. We mentioned this last week, reporting criminal convictions. You guys know you have to do a background check to get your license. It's part of the application process. Once you're licensed, you're not free and clear. Once you're licensed, if you get yourself in trouble, you have got to report that to the Real Estate Commission. I need you guys to note this word says convicted of any felony or misdemeanor. Does that say once you've been charged? You know, you need to look at that verbiage. If you've been charged, you've not been convicted. You're only convicted when the judge's gavel comes down and they say guilty. So once you've been convicted, you have got to report that to the Real Estate Commission within 60 days. Are they going to do anything to you? I cannot answer that. It's a case-by-case scenario. It depends on what you did. It depends on the crime. I think an example that could get you in trouble is if you mishandle somebody else's money. The Real Estate Commission is going to frown upon that. The other thing you have to report, does anybody have another professional license? Profession, it's not your driver's license. This is a professional license, an occupational license. If you get yourself in trouble with your other occupational license, you've also got to report that within 60 days. Are you going to get in trouble? I don't know. I can't answer that. This is what I do know. I compare, in this scenario, I compare the Real Estate Commission to mama. I don't know what kind of house you grew up in, but in my house, it was always better if you fessed up and told mama you did something wrong than let mama find out about it on her own. Did anybody else grow up in a similar house? Mama? Yeah. Think of the Real Estate Commission as mama. Don't let them find out on their own that you got in trouble. You will get disciplined. You may get disciplined if you report. Everybody with me? You've got to report it. We did an educators conference back in March, I guess it was. And one of my favorite pieces of the educators conference is they tell us the most common complaints from the previous year. Do y'all know this was the biggest, one of the biggest violations in 2021? Agents failing to report their conviction. And I don't know how the Real Estate Commission found out, but they did. So they're in trouble, not only possibly for the conviction, but they are definitely in trouble for not reporting it. Anybody plan on getting a real estate license in another state? Maybe South Carolina, Virginia, anybody on a border, a couple of you? If you're licensed in another state, let's say you get your license in Virginia and you get yourself in trouble with the Virginia Real Estate Commission, you've got to report that to the North Carolina Real Estate Commission. It's an occupational license. Questions on this? Okay. We talked in Unit 8 about our residential property and owner association disclosure statement. Particularly, we talked about the Residential Property Owners Disclosure Act, the RPOs, Residential Property and Owners Association Statement, there it is, and the MOG, the Mineral and Oil and Gas Rights. Remember, these two documents are seller disclosures. Who is responsible for completing seller disclosures? I can see your mouse move. The seller completes seller disclosures. Can I complete the seller disclosures for them? Absolutely not. Seller disclosures, these are mandatory forms with optional disclosure, which means the seller has to complete them, but they have the right to say no representation. Remember, you guys, the seller's not held to license law and commission rule. The seller's not licensed, so they don't have to disclose. They have the right to say no representation. The agent has to disclose. The licensee has a duty to disclose all material facts. So regardless of how the seller completes the RPOs, we have a duty to disclose material facts. The seller has the option to say no representation. Mandatory forms, optional disclosures. What questions do I have on that? We talked in Unit 21 about our responsibility for the closing statement. It's our job to make sure that every client gets the closing disclosure. Most of the time, the attorney does that, but we still need to make sure it happens. What another good reason to attend closing? To make sure that that transaction happens, to make sure that the client gets their closing documents. We also have a duty to review the closing disclosure for accuracy. Do your head. Am I responsible for verifying all of the figures? All of them? There's your key word there. Every single figure. Am I responsible for that? No. I can only verify what I know, what I have access to. So we can look at the sales contract and make sure that the purchase price is right. Do we know now how to prorate taxes? How to calculate interim interest? Can I verify those numbers? So we have a duty to review it for accuracy, what we know or should reasonably know. And if and when you find any errors, we've got to report them. Failure to reporting could be willful omission. So if and when you find any errors, you've got to call the paralegal and or the lender and say, these taxes aren't right, or the additional earnest money is missing, or the phone call I had to make one time and say, my commission's not on here. We've got to review these things for accuracy. I'll please make a note to go back and review Unit 21. Unit 21 is our contract to closing process. So in addition to the mini CD, how much does the buyer have to bring to closing? We also need to be familiar with the contract to closing process. The buyer's due diligence period, the things that they should be encouraged to investigate and inspect. Any questions? Starting on page 725, we're going to talk about our trust account. And there's a lot more to know about trust account, escrow account. The Real Estate Commission says if we're familiar with the stuff on 725 to 727, then we know what we need to know about the trust account. So first off, we need to understand what a trust account is. A trust account is an account that has somebody else's money in it. Your money does not belong in a trust account. Why don't you guys tell me in a private chat, what are some examples of monies that we may have in the trust account? What are some examples of monies that we may have in the trust account? Examples of monies that we may have in the trust account. Other people's money. So I'm seeing a lot of you say earnest money. I would agree with that. Earnest money, remember the escrow agent, the closing attorney, for example, will hold the earnest money deposit. They're the impartial third party. I'm also seeing a lot of security deposits for the tenant landlord relationship. We're going to keep those in a trust account. A couple of you said due diligence. Due diligence does not go in the trust account. Who gets the due diligence fee? Remind me who gets the due diligence fee. I see your mouths go. The seller. That's right. So due diligence is money that's paid directly from the buyer to the seller. So we're not going to put due diligence. A couple of you said rent. I'm going to say that depends, but possibly we could run our rent. If you're a property manager, you could run rent, there we go, through the trust account. What I did not see, and this makes me happy, is anything to do with your money. So commission doesn't belong in the trust account. Money to pay your bills doesn't belong in the trust account. Trust account is an account that has somebody else's money. With the trust account, there are three primary features. There are three things that distinguish a trust account. It's separate, and that it's separate from your operating account. If you're a property manager or you're a firm that maintains a trust account, you got two accounts. You got the trust account that has somebody else's money, and you have the operating account that you pay your bills, pay your agents. Your money goes in the operating account. The trust account is custodial, which means the people that have access to it are not people that have money in it. They don't have that. Your buyers and sellers, for example, don't have access to it. It's custodial. And then the monies in the trust account have to be available on demand. Let's say it's a really, really bad day and all of your contracts terminate today. We need to be able to pay out that earnest money to the buyer or seller today. It's available on demand. You cannot say, let me wait until Friday when I get paid. If every single thing terminates today, you've got to be able to pay out that earnest money today. They can be withdrawn at any time without prior notice. Separate means it's not your operating account. It's separate from your operating account. So again, if you're a firm with a trust account, you have two accounts. You have a trust account that holds, is just a holding ground for other people's money. And then you have your operating account that you pay your bills, receive your commission, etc. Some basic required features. Again, it's a demand deposit account, which means the money's got to be available. The money, the trust account has to be in a bank, FDIC. Sometimes you walk into a bank and you see the sticker on the front door if they're FDIC or not. Some credit unions, for example, are not FDIC. So if you're opening a trust account, you need to make sure. The bank has to lawfully be doing business in North Carolina. They don't have to be located in North Carolina, but they have to lawfully be doing business here. And the bearer of the trust account has got to agree to make their records available at any time for the Real Estate Commission. If you maintain a trust account, you got to be prepared for the Real Estate Commission to walk in the door at any time and say, show me your books. And again, your response should not be, oh, give me just a minute, I got to balance it real quick. You should be able to walk in the door and they say, here you go. So it's got to be available for inspection. Anything that you have has got to actually say trust account or escrow account on it. So your signature cards, bank slips, deposit tickets, checks, all your documentation have got to spell out that this is a trust account or an escrow account. The reason for this, let's say you are a one-man firm or you have a one-man firm and that man dies. We don't want somebody else's money frozen in their estate. So by identifying this as a trust account, the estate knows that it's somebody else's money. And you have to maintain accurate records. What's the money coming in? What's it for? For example, it's, seller Smith, buyer Bob, earnest money deposit for 123 Main Street on May 17th. You have to have accurate records. Money coming in, money coming out. Again, you guys, you're dealing with somebody else's money. So you need to make sure you can account for it. You need to make sure that it's accurate.
Julie.
Yes.
So the appendix question in the back says a broker's trust account must comply with all of the following. And one of them is it can include up to $100 of the broker's money to cover bank charges.
I'm getting ready to talk about that next. Yep.
Gotcha.
Okay. Real estate firms, escrow agents only need one trust account. Let's say you're a firm that does for sale and for rent. You can have earnest money and security deposits in the same trust account. You could choose to have two, but you're only required to have one. The exception to this rule is if you're a property management company and you manage HOAs. Each HOA needs their own separate trust account. So if you're a property management company and you're managing 10 HOAs, you need 10 trust accounts. That's the exception. The biggest violation, is commingling. Commingling is having your money in the trust account. You cannot commingle. Remember, the basic definition of a trust account says it's money belonging to someone else. So your money does not belong in the trust account. You cannot put somebody else's money in your operating account. That's commingling. This might be innocent. You might get a phone call from the city today that says, if you don't pay your bill today, I'm going to cut off your power or cut off your water. And you think, well, gosh, I don't want to lose power. And I know I get paid on Friday. So I can just borrow money from the trust account, pay my power bill. And then Friday, when I get paid back, I'll put it back in there. Can you do that? That's like the very definition of commingling, isn't it? So no, you cannot. The exception is the question I just got from Cassandra. So the exception to commingling, if your bank charges a monthly fee, you can have up to $100 of your own money in the trust account to cover that fee. And when that dwindles down, you can replenish it. No more than $100. And it's only if your bank charges a fee. It's only to cover the fee. So Cassandra, does that answer your question? Trust accounts can be interest-bearing accounts. Who collects the interest? The bearer of the trust account, whomever's holding the trust account. Parties have to agree to it. For example, we have this verbiage covered in our sales contract, our offer to purchase and contract. So they can be interest-bearing accounts as long as the parties agree to it. Any questions so far on the trust account? Sure, you can keep the interest. You collect interest each month and you transfer it to your operating account. You can have it, you can collect interest. You can't keep it there because that would be commingling. That's your money, right? Then I might have just answered your question. Let me know if I didn't, but you can transfer it. Once you collect interest, then you transfer it to your operating account. That I don't know about. Aaron, that I'm not sure about. I got you. Yeah, you'd have to come up. That's a good question. What if the client doesn't allow it? Then I guess, I don't know, you'd have to come up with something else, but you cannot agree to do business with that customer either, right? Like, I want to make my 12 cents off of you, dang it. Most, I've yet to meet anybody that actually that has an interest bearing account. So they can, if the parties agree to it. I don't want you to think that we're a bunch of money greedy people sitting around collecting interest off of you. We can if you have a trust account, but that doesn't always mean that we are. There you go. Use your interest to pay your monthly bills. There you go. Is everybody good with that? With the why the $100? Because if you have somebody else's money in and they charge you $12 monthly fee, that $12 coming out of somebody else. Remember, it's on demand. So you can't say, well, here's all of your money except for $12. I'll get you that in just a second. So that's why you're allowed to have the $100 to cover those fees. Yep. Okay. All right. Let's take our break. When we come back, we'll a little bit more about the trust account. All right. We're back. You guys may have to bear with me later today. My AC is out right now, and so far so good. I got fans on me all over the place, and I can keep adjusting up as need be. But the guy's coming out this afternoon, but that doesn't really help me this morning. So I'm hoping I stay cool enough. This is not a good time of year to have your, I guess it's never a good time to have your AC go out, to be fair. It's usually not a good time for appliances to break in general. All right, so let me take attendance. You got, I think we were talking about yours breaking last week. And now mine's out today. So that's all right. That's all right. All right. 92. Yeah. Oh, now you're just bragging. You're cold. All right, let's see. And I know I'm standing here drinking hot coffee. My husband and I had a conversation about that too. But I'm like, I can't not drink coffee. I guess that's a conundrum, isn't it? All right. Let's see. Yes. Yes, I can. Yeah. And I've taken attendance. So if you're just now joining us, please let us know. I need to be up in the mountains with you guys, don't I? All right. Do your head one way or the other. Are all firms required to have a trust account? Does everybody have to have a trust account? And the answer is no. You only need a trust account if you plan on holding somebody else's money. So if you're a property manager, you almost always have to have a trust account, right? Because you're going to have security deposit. If you're a real estate firm, maybe you have a trust account. Maybe the firm has a trust account. Maybe they allow closing attorneys must have a trust account. So what's happening is that real estate firms are starting to do away with trust accounts. We figure if the attorney has to have it anyway, might as well let them be responsible for it. When you join your firm, they'll let you know if they have a trust account or not. And if they do, they'll let you know the rules, how they want you to handle that. Some of your bigger brands, your more well-named brands still have trust account, but a lot of us mom and pops are doing away with it. So if the firm has a trust account, the BIC is responsible for it. They can have an unlicensed employee manage it, but ultimately the BIC is responsible for it. Back in my day, my admin days, I maintained the trust account for our office. I wrote the checks, I deposited the checks. I got to leave 15 minutes early every day for lunch and go to the bank to make the deposit. Wrote the checks out when it went to closing or terminated. But if the real estate commission walked in the door for the trust account, they weren't going to talk to me, were they? They were heading straight to the BIC. So the BIC, one thing they're responsible for if they have it. Records have to be current and accurate. It doesn't specify how current, how accurate. I mean, accurate, of course. It doesn't specify how current, but you know, the bank statement comes out once a month, right? So what better opportunity to sit down and make sure that it balanced, and it's got to be accurate. Again, you got to see money coming in, money coming out. There's rules on disbursement. You cannot disperse, for example, the earnest money deposit more than 10 days prior to settlement. We got to get that money from the real estate firm to the closing attorney's office. Again, if you join your firm, when you join your firm and they have a trust account, they'll let you know the procedure for getting that money. If for some reason the earnest money is in dispute, we know our contract says if the buyer terminates within due diligence, they get the earnest money back. If they terminate after due diligence, the seller gets the earnest money. But the parties have to release the earnest money if we terminate. So if the earnest money is in dispute, if either party is not willing to release the earnest money, whomever has the trust account, the escrow agent, cannot release it for them. They cannot release disputed monies. So the bearer of the trust account will just hold it until they can come to an agreement. And after a certain amount of time, and honestly, I don't remember what that certain amount of time is, but after a certain amount of time, the escrow agent has the option to release the funds to the clerk of court's office and let the two go downtown and hash it out. So even though the escrow agent has the contract in their hand and everybody signed agreeing to do this or that, both parties have to agree to release the earnest money. The escrow agent cannot make that decision for them. What questions do I have on that? Disputed funds can't be released by the escrow agent. Trust account rules say that trust monies, they have to be deposited within 3 banking days of receipt or contract formation. Earnest money is not due until we're under contract. So typically the way it works, we go under contract. The buyer pays the earnest money. The escrow agent has 3 banking days to get it into the account. We go under contract, the buyer hands over a check. We have to deposit within 3 banking days. What if, though, there could be a scenario where the buyer asks the agent to hang on to their earnest money while we're still negotiating the offer? So we're not under contract, we're in the throes of negotiations, and the buyer says, will you hang on? Now we've received it, but remember, it's not due until we're under contract. So just because you've received it, you're not going to deposit it until you're under contract. If it never becomes a contract, give that check right back to the buyer. They don't owe that money. If it does become a contract, now your 3-day clock starts upon contract formation. And then you have 3 days to deposit it. And that's what we mean by receipt or contract formation. Y'all remember, the buyer doesn't owe any money until a contract is formed. So we're not going to deposit. Everybody good with that? I'll talk about the exception in just a second. We're not going to deposit their money until a contract is formed. The exception to this rule is cash. If you're ever handed cash for the earnest money deposit, get it in the bank right away, whether you're under contract or not. Your firm very well may have a policy that says no cash. But if you ever receive cash, get it in. You don't have to wait for cash to clear the bank. So you're negotiating the offer. The buyer hands you $1,000 in cash. Get it in the bank. Get it to your BIC so they can get it in the bank. That offer never becomes a contract. You can turn around and write them a check. You don't have to wait for it to clear. Again, your firm very well may have a policy that says no cash. Cash is very dangerous. You guys, as soon to be provisional brokers, PBs cannot walk around with somebody else's money. PBs cannot walk around with somebody else's money. If your buyer says, here's my earnest money, hang on to this for me until we form a contract, you need to get it immediately to your broker in charge to hang on to. If a contract is never formed, we'll get it back to the buyer. But provisional brokers deliver all monies immediately And although option money and due diligence fee is not trust money because they don't belong in a trust account, they're paid directly to the seller. Probably in the transaction, we're going to touch them at some point. We go under contract. The buyer writes a check to the seller. The buyer's going to give that check to their agent. Buyer's agent's going to deliver it to listing agent. Listing agent's going to deliver it to seller. So anytime you have somebody else's money in your hand, you're responsible for it. And when you're dealing with due diligence or option money, you're simply acting as a courier. This says no more than 3 days. My advice to you is get it to where it needs to go. Because again, when it's in your hand, it's your responsibility. So if you're acting as courier, if you're delivering it, make that a priority. Yeah. And now who's responsible for it, right? So get it to where it needs to go. Everybody good with that? Don't hang around, don't walk around with somebody else. PBs can't, brokers shouldn't. All of us are responsible for safeguarding money, earnest money, due diligence, option money, security deposits, rent, regardless of whether or not your firm has a trust account or not. Maybe your firm has a trust account, maybe it doesn't. But at some point in the transaction, you will have somebody else's money in your hand. And you're responsible for it. Questions on trust accounts. Let me say one more thing. I'm sorry, let me go back. If you have the due diligence fee, let's pretend that you're the buyer's agent. You go into contract, yay. And you and your buyer are going to meet at, Sunday afternoon at Chick-fil-A parking lot so you can get the due diligence and the earnest money check. So you guys meet, the buyer hands you the 2 checks. You say, great, I'll take care of these first thing tomorrow morning. I'll be at the bank or, whatever. We'll take care of these first thing tomorrow morning. And once you guys part ways, the buyer calls you and says, do not deliver that money. We have got to follow our client's instructions. So if they, again, you guys, I'm just acting as a courier. So if my buyer calls me and says, don't you deliver that due diligence to the seller or the listing agent, I've got to follow their instructions. Now I can tell them this could be grounds for breach. The seller could come after you for this money, I can warn them about what the contract says. But because I'm simply acting as the courier, I've got to follow their instructions. Question comes in, what do you do with it if there's no trust account? You get it to the escrow agent. You get it to the closing attorney. Your BIC can still hang on to it until a contract is formed. And then once you go under contract, you go back and get it from your BIC and take it to the closing attorney or whomever the escrow agent is. Again, when it comes to other people's money, we're acting as couriers. We've got to follow their instructions. If it's in our hand, we've got to follow their instructions. Like we said, when the money's in your hand, it's your responsibility. Questions on the trust account? Earnest money. That's right. What do we document? Everything. If you didn't learn anything else in the last 2 months. Was this a class where somebody told me they're going to put that as a tattoo, get a tattoo that says that? Yeah, I think so. Just a little refresher. You can put it on your inside wrist or something, document everything. The last little section in this, the last little piece in this section is a nice refresher on BPOs and CMAs. We talked about BPOs and CMAs in our appraisal unit back in unit 17. So now we're looking at the comments from the commission on pages 727 and 728. Remember, provisional brokers cannot do BPO or CMA for a fee. You can do one, but you can't do it for a fee. Nobody can charge a fee as part of our general brokerage duties. It's our duty, it's our responsibility to do BPO CMAs for sellers and buyers. Remember, we are just real estate agents. We are not appraisers. We do not get to determine value. That's the appraiser's job. What I'm providing to the consumer is probable selling price or probable lease price, probable sales price. Article 6 of license law, again, you don't need to know that, but you do need to know it's covered under license law. If you are performing, or when you get to the point where you're performing a BPO or CMA for a fee, you've got to follow the laws, license law of Article 6. Your BIC will help you, don't worry. You'll get a lot more training, BPO, CMAs. And since we document everything, doesn't it make sense that it needs to be in writing? Keep it all. So that 707 to 728 are the license law and commission rule comments. Remember, everything in Appendix A is license law and commission rule. I think if you guys focus on 707 to 728, you get the major highlights of the license law and commission rule. There are some things covered that are not in the comments. There are some things covered in the syllabus that are not in the comments. So what we're going to do now is go back. We're going to kind of be scattered all over the place, but we're going to go back through Appendix A and get the things that you need to finish this section up for the syllabus. Everybody good? So I'm kind of jumping around again. Yes, I provide you page numbers. Remember what the commission says, though. If we follow the syllabus, we've covered everything. So let's go back. Pick up a provision on page 611. 611 is our commission rule. We have a commission rule that says that we have to have our pocket cards on us at all times when we're engaging in brokerage activities. Once you pass your state exam, they will actually mail you a real estate license, a nice 8.5 by 11. Isn't this nice? Get you a frame for it. You worked hard for this thing. So get you a frame. Hobby Lobby puts it 50% off, you know, every 2 or 3 weeks, right? So run out and get you a nice frame. In addition to your license, each year that you renew, you will get a pocket card. We'll talk about the renewal process in just a second. Every year that you renew, you'll get a pocket card. You can either print it out and it comes in a card about this big that fits nicely in your wallet. You can also now get a digital pocket card. You can be like me and have both, just in case. Anytime you're engaging in brokerage activity, you need to have your pocket card on you, either the wallet or the digital version on your phone. If conducting an open house, engaging in brokerage activity. Yes. So do you need your pocket card when you're doing an open house? Yes. Is attending a continuing education class a brokerage activity? Yes. As a matter of fact, your pocket card is admittance to CE classes for a lot of schools. Okay, so you have your pocket card on you. If you're going to go out of town and you're transferring, ladies, you'll understand this, you're transferring from your weekday purse to your weekend purse, your party purse to go out of town, grab your pocket card. Because what if you're sitting in a restaurant and somebody comes up and starts talking about real estate? You get the opportunity to hand out a business card for a referral. Is that a brokerage activity? Yes. Again, we'll talk more about the renewal process in just a second. In addition to the individual broker being licensed, the firm also has a real estate license. The firm is required to display their license. So when you affiliate with your firm, you'll go in, see your license. Just to point out, pages, 611, I'll let you guys flip. 612 to 613 is the actual commission rule on agency agreements and disclosure. There's another piece for you. Flipping through, there's retention of records on 615. There's the broker in charge on 617. Some of these things that we talked about in the comments, we're now seeing in commission rule. So we kind of abbreviated it a little bit for you guys in the comments, because I think we've all decided that law and rule is not an easy, fun read. So we abbreviated it for some in the comments. It can't hurt you guys just to flip through. You want to know more about agency agreements? There's the official rule on it. Let's fast forward again to page 627. There's a rule that says we cannot disclose the terms of an offer without the permission of the offeror. Why don't you guys remind me in the chat who the offeror is, and do not tell me it's the buyer. Who is the offeror? Who is the offeror? The offeror is the person making the offer, the giver of the offer. Maybe it's the buyer, maybe it's the seller, right? A counter offer, remember those roles reverse. So maybe it's the buyer, maybe it's the seller. The offeror is the giver of the offer. And in order for you to disclose any terms of their offer, you have to have their express authority. You have to have their permission. Do you think anybody in their right mind is going to give you permission? Yeah, go ahead and tell them what I offered so they can have the opportunity to beat it. Probably not. As the listing agent, if you're in a multiple offer situation, guys, agents will call you and say, I'm working with a buyer, we're getting ready to submit an offer. What's the highest offer you have in your hand right now? They can ask. There's no rule about asking. The rule says that you can't disclose. Do I have everybody on the same page with me? Just because they ask, what's the rule say? The rule says we cannot disclose. You may be in a situation one day, this is where real estate gets really fun. What if you're working with two buyers, both interested in the same property? You're writing up two offers for two buyers on 123 Main Street. Can you pit your buyers against each other? Can you tell one buyer, I know for a fact, this is how much they offer? Not without their permission. How do you deal with that situation? All buyers have a different risk tolerance. So you have separate conversations. I would provide the same CMA for both, and I would have separate conversations about what they're willing to offer, because they're all different. Question comes in, will we be allowed to say it's over list price? I would, that makes me a little nervous, right? I'm not giving an exact amount, but you're pretty much saying, we can't shop offers, we can't pit buyers together. So when the other agent calls and says, what's that? Well, I have other offers, but they're over asking price, because then they start questioning, are they trying to get me to go over? Do they actually have something in their hand for that amount? Does that make sense? So I would even caution from general statements. Again, agent blows my mind. But they'll ask because they're trying to do what's best for their client, right? You need to remember who your client is. Always remember who your client is. Any questions on this? All right, let's skip ahead again to page 637. Talking about our license renewal. The Real Estate Commission's fiscal year is July 1st to June 30th. They do not operate on a typical calendar year. And all of our licenses expire on June 30th each year, unless we renew it. We renew our license each year by paying the renewal fee. And the window of opportunity to pay our renewal fee is May 15th to June 30th. The renewal period is May 15th to June 30th. You have got to pay the fee. You've got to pay the renewal fee no later than 11:59 p.m. on June 30th. Failure to pay the renewal fee means at the stroke of midnight on July 1st, your license is expired. We'll talk just a second how you reinstate an expired license. I will talk about this. Can you engage in brokerage activities on an expired license? Can you get paid on an expired license? You got to keep it active. Again, we'll talk more about that. Y'all want to know what I did yesterday? I'm such a nerd. I paid my fee. I'm done. I don't have to worry about it. The only reason I didn't do it on May 15th is because it was on Sunday. You know what I'm saying? So as soon as I woke up yesterday morning, for the past, I don't know how many years, and including this year, the renewal fee is $45. It only costs us $45 to renew our license. So May 15th to June 30th, failure to renew by June 30th, by the end of June 30th means on July 1st, your license is expired. You have to do this each year, every year, $45 every year, May 15th to June 30th. Remember we put that letter from the commission and Learn Test Pass. I'll point it out to you guys again. It talks about you guys getting your license during this period. And you guys happen to fall in this period for you going to the state exam or at least finishing the class. So I'll point that letter out to you again so you know what happens if you do get licensed during this time. The active license is the only license in which you can get paid. And in order to maintain an active license, it has to be current. And when I say current, I want you guys to think currency. A current license has everything to do with paying the fee. It has nothing to do with education. So how do you keep a current license? You pay the fee. You show them the money. So when you show them the money, when you send that's only one piece of it. So a current license can be active. The second piece of it, once you drop your provisional status, you got to do your CE every year. We will talk about CE in just a second. Continuing education. Bear with me. We'll talk about CE in just a second. Guys, remember, as a provisional broker, to be active, you have to be affiliated with a BIC. So as a provisional broker, you're not automatically active. When you get your license, it's on inactive status. How do you activate your license? You affiliate with a firm, with a BIC. So all you have to do each year, once you drop your provisional status, all you have to do each year to maintain an active license is pay the renewal fee, keep your license current, and do your CE. That's it. We'll talk about CE in just a second. A current license can also be inactive. Why is it current? Because you paid the fee, because you showed them the money. It's current because you paid the fee. So what I'm saying is, a current license can be active, a current license can be inactive. Your current, again, why? Because you paid the fee. You're inactive because maybe you're PB without a BIC. Maybe you didn't do your CE on time. Maybe you didn't do your post licensing on time. Maybe you choose to be inactive. Maybe you think you're done with real estate, or maybe life happens. You're going to start a family or care for an elderly parent or start a new job. Who knows? All you have to do to maintain a current license is send them $45 every year. Send the renewal fee. What happens if you don't do that? I'll talk about that in just a second. Personally, I think it's worth the $45 every year. Again, I'll explain why in just a second. Yes. Yeah, $45 is not bad. Do you have a question? You could ride for the rest of your life on an inactive license. Maybe you never activate it. You get your license and you never activate it again. Maybe something comes up and you're putting real estate off to the side for a minute. Pay the fee. If your license is inactive, to reinstate an inactive license, it depends on what your education deficiency is. You've been paying the fee, so you've kept it inactive. You have the choice to do CE. If you don't have a CE deficiency, you just submit the form, poof, you're active again. If you have a CE deficiency, you have to get caught up. Less than 2 years, you got to get caught up on some CE. They'll make you do the update again. I'll talk about CE in just a second. You got to do the update. You got to do some electives. This is reinstating an inactive license. So let's say you've been inactive for 1.5 years and you've not taken CE. They'll say, fine, we'll make you pay the fee. I'm sorry, we'll make you do CE this year and we'll make you do an extra elective, something like that. It's a call to the real estate commission. If your CE deficiency is more than 2 years, they're going to make you do the current year CE, and they're going to make you go back and take some post licensing. I had a lady once in my post licensing class. She never activated. She had an inactive license for 10 years. And she woke up one day and said, hey, I want to do something with this license. And they said, you've never in 10 years had an active license. And she never took a CE or a post licensing class. So they made her do all 3 post licensing then. Is that fair? Goodness, I think so. I don't know what real estate looked like 10 years ago. I honestly don't remember, but I promise you something's changed. So they had her come back and do the 3. They treated her as if she just got licensed, but she kept it inactive every year. Please, please, please remember, a current license, no, I don't want to say that. A current license has everything to do with money. It has nothing to do with education. Okay, so you're up to date would be a better word to say here. You're up to date on your CE. Up to date. Okay. Current means you've paid the fee. Do I have everybody? If your license is current, you've paid the fee and you're active or inactive. Failure to pay the fee means at the stroke of midnight on July 1st, your license is expired. I don't care if you've done your education or not. Failure to pay the fee means midnight on July 1st, your license is expired. How do you reinstate an expired license? Again, it depends on how long it's expired. If it's expired for less than 6 months, you pay the renewal fee and you pay a reinstatement fee. So 45 times 2 would have you back in less than 6 months for what, $90. If your license, if you want to reinstate an expired license and it's been expired 6 months to 2 years, you pay the renewal fee, you pay the reinstatement fee. You go back and do a post licensing again, a post licensing class of your choice within 6 months of reinstatement. Or you go back to PSI Testing Center and pass a state exam again. Expired license, 6 months to 2 years. Yes, you have to pass the test for post licensing. What happens if your license is expired for more than 2 years? Are y'all ready for this? Literally, hang on to something. You guys ready? If your license is expired for more than 2 years, you get to start all over in pre-licensing. Is it worth sending the $45 in every year? I think so. I can't answer that for you, of course, but I think so. Both. It's in the syllabus. And the Real Estate Commission says if we cover what's in the syllabus, we're covering what you may need to know for your exam. Guys, the last live class, I should say in-person class that I taught, I had 2 people that had a real estate license. They told them it expired. And they were sitting in my pre-licensing class again because it expired more than 2 years ago. You got to start all over. So again, I ask you, is it worth paying the fee every year? I can't answer that for you. I see lots of head shaking yes. What questions do I have on this? Licenses are either current or expired. A current license can be active or inactive. Everybody, please listen to me. The Real Estate Commission says, if we cover what's on the syllabus, it's a good candidate for your exam. And this information that I'm going over is covered on the syllabus. Questions on a current or expired. A current license has everything to do with the fee, nothing to do with education. Provisional brokers can do just about anything that a full broker can do as long as you guys are supervised by a broker in charge. I think we're all pretty good on that. Yes, PBs are inactive until you affiliate with a firm. And as long as you're under the direct supervision of a broker in charge, you can do just pretty much anything a full broker can do. There are some exceptions that we have talked about. For example, can you charge a fee to do a CMO or BPA? Can a provisional broker charge a fee to do a CMO or BPA? No. Can a provisional broker walk around with somebody else's money? Can you hang on to earnest money deposit? No. Can a provisional broker be designated opposite of their broker in charge? Designated? No. So there are a few exceptions. But for the most part, the PB can do just about anything that a full broker can do. If your renewal fee or your application fee, when you submit your license, if either one of those are returned for lack of funds, that may result in a disciplinary action. Make sure you got the money in your account before you submit. Don't let that stuff bounce. Okay. Let's talk about CE. Remember, we just said the commission's the commission's fiscal year is July 1st to June 30th every year. The renewal period is May 15th to June 30th. The renewal period is your time to renew your license. How do you renew your license? You show them the money, you pay the fee. That's how you renew your license. To have an active license, in addition to renewing it, we have got to do 8 hours of CE each year. The deadline to do CE every year is June 10th. June 10th, June 10th, June 10th. Y'all write that date down. June 10th, every year. Failure to complete CE by June 10th every year means when you wake up on July 1st, assuming you've paid the fee, your license will be inactive on July 1st. Here's the deal. There's a blackout period from June 11th to June 30th. No educator provider in the state of North Carolina can offer CE. They don't allow it. At last count, you guys, I saw our last newsletter, there were 108,000 licensees in the state of North Carolina. That doesn't include firms, education providers, and instructors. We're all renewing between May 15th and June 30th. They have got to cut CE off to give time to process all this. So they cut CE off on June 10th every year. If you do not do your CE by June 10th, then you will be inactive on July 1st, assuming you've paid the fee. Now, I got good news for you guys in just a second. We do 2 CE classes each year. We do an update course. The update course is the Real Estate Commission. We all get the same information in the update course. It's the Real Estate Commission's opportunity to update us on current things. And then we also have a 4-hour elective. And the elective is a topic of your choosing. If you have a niche, if you have a certain area you're interested in, maybe you want to learn more about, I can almost guarantee you there's an elective course for that. I'm getting ready to talk about that in just one second. Like we said, the cutoff is June 10th. They usually release the new information for the year like August or September. So you can start taking your CE in the fall. I do not suggest you guys waiting until June 10th. The only time they would grant an extension is if you can prove a hardship. And I'm here to tell you right now, I got busy and I forgot, is not a hardship. An allowable hardship is going to be active military deployment or serious medical issues. For COVID-19 was considered a hardship. So usually in the fall, August or September, schools start offering CE again. So think about this. Let's say August something. You have August something until June 10th to do 8 hours. That's really not bad, is it? So for your active license, you pay the $45 and you do 8 hours of CE. That's all you got to do to maintain an active license. I know there's a lot of licensing bodies out there. There's a lot more involved. So what's your good news? You guys want some good news? You guys don't have to do CE your first renewal period. You get your first renewal period off. So whenever you get your license, draw yourself a timeline. And whenever you get yourself a license, the first time you hit May 15th, you don't have to do CE. So all of you are already past this renewal period. If you get licensed in June, you don't have to do CE again until 2 years, second renewal period. So whenever you get your license, you do not have to you have to pay the fee. Always pay the fee. Yes, pay the fee, but you don't have to do CE. Is that good news? The thinking is you guys just came out of you just came out of post, you have the current information, you have the current material. So they give you your first year off on CE. Isn't that nice? And as a reminder of our very important dates, June 10th is CE, pay the fee by June 30th. June is a big month at the Real Estate Commission. June 10th is CE, pay the renewal fee by June 30th. Questions on CE? Of course, commission rule also covers post licensing. We've talked about that. In 2020, July 2020, they changed it to the 18 months. So it used to be you guys had 3 years to do your post licensing. Now it's 18 months. So if you see some old literature that says 3 years, know that that was changed. Again, they may grant an extension if you can prove a hardship. But a hardship is not, I got busy and I forgot. COVID was a hardship. They granted extensions for post licensing. Your post licensing consists of 3 30-hour classes. Completion of these 3 classes means you can drop your provisional status and you're just a broker. Yes. Yes, and your renewal fee is rolled into your application. So whenever you submit your application, that's part of that renewal fee. So you won't have to pay the separate fee. It's all part of it. Trust me, you'll get, once you pass that state exam, you'll get emails from the commission explaining, helping you out with all this as well. Questions on post licensing or CE? Post licensing will be in the format like we're doing now. Yeah, I mean, some schools are starting to go back in person. We're starting to talk about it. I might do an in-person post later this year. That'll be pretty exciting. I'm looking forward to that. But yeah, either online via Zoom or in person post licensing. The question was about CE or post licensing. Thought about it. I miss you guys, you know. Depends on, there's schools all over the state of North Carolina. You can find a real estate school anywhere. Usually Carolina does Winston though. We do Winston. What do you guys remember about timeshares? You can show me. What do you remember? What do we remember about timeshares? 5, 5, 5, 10. 5, 5, 5, 10. Do you remember what that means? The first 5 means the right to occupy a unit during at least 5 or more separate time periods over at least 5 years. The buyer has a 5-day recession period, which means they have 5 days to cancel, 5 days to terminate. And the developer has to keep money in trust accounts for 10 days. Why? Because if the buyer rescinds, we got to get that buyer their deposit back right away. So if we have it in a trust account for 10 days, we make sure it clears. The developer does have the right to verify that the funds have cleared, that the check is cleared before they reissue. And remember with timeshares, this is the only time that the Real Estate Commission will get involved with matters of money. And the Real Estate Commission can fine a timeshare developer up to $500 per violation. I think the only other thing we need to worry about with a timeshare is just some basic definitions. Please turn with me to page 596. 596. And on 596, there are some definitions. We don't need to know all of them, but there are a few. Most of these we've already talked about. The developer is the person that creates the timeshare, manages the timeshare. The project broker is the licensee that's maintaining the day-to-day operations of the timeshare. Think of the project broker as the broker in charge of the timeshare. Think of the project broker as the BIC. Timeshare is the right to occupy for at least 5 days over at least 5 years. So we actually define timeshare. The timeshare instrument is the document. We record that document. Over on page 597, the timeshare salesperson is the individual who acts on behalf of the timeshare selling units. The unit is the area meant for occupancy. So just a couple of dashes to be aware of. You guys see that green star? Nothing to get excited about, just be aware of. I am going to go back for 1 second because I want to make sure you guys see at least. I need you guys to understand that 5 is the minimum. So if your test says 10 separate time periods over 10 years, is that considered a timeshare? Yes, because it's at least 5. 5 is the minimum. Everybody good with that? 5 is the minimum. 4 separate time periods over 4 years, is that a timeshare? No, because you don't meet that minimum. Everybody with me? Everybody see that? At least 5 years. 5 time periods over 5 years.
Hey, Julie.
Yes.
I was a little confused about that because my sister-in-law, she takes her family to timeshares all the time. And I was like, how does she do it? Because it says 5, but that's the least amount. So she can go as many times as she wants.
So she may not have a true definition of a timeshare then. You know, and it's hard to answer that without actually, but some timeshares are transferable, which means they'll let you go. You're still in this timeshare, but they'll let you go somewhere. I had a friend that took his timeshare one year and went to Scotland instead of Myrtle Beach. He was able to transfer his week from Myrtle Beach to Scotland. Isn't that a big change? I'd go to Scotland over Myrtle Beach any day, but you would. So some may allow you to, but you still have this commitment of at least 5 or more separate time periods over at least 5 years. Okay. All right. So we got a key point review. Guys, I like the key point review on 729 again. I mean, Appendix A is a couple hundred pages. So use the comments that we went through starting on page 707. Use the key point review that starts on page 729. Use the abbreviated, the Cliff's Notes, if you will. And then there's a student quiz in your book, License Law and Commission Rule on page 737. All right, don't go anywhere just yet. Let me make sure you guys have this. And I'm going to talk about what's getting ready to happen now. We're getting ready to take a break, but hang on. Bear with me. Everybody good? Everybody have these page numbers? Okay, I'm going to stop sharing just for 1 second. Hang on. And what we're going to do when we come back from break, we're going to talk about safety. But before we talk about safety, I have a little video that I would like you guys to watch. So I think what I'd like to do, hang on, instead of everybody trying to stream and watch my feed and all this other stuff, I'm going to give you guys Okay, I'm going to give you guys the link. And then instead of a 10-minute break, we are going to take a 15-minute break. Now, this is like a 3-minute video. So I'm giving you guys a couple extra minutes. Is everybody good with what we're doing? We're going to take a longer break. You're going to take your 10-minute break. You guys still deserve a 10-minute break, but I also want you to watch the video on safety that I'm getting ready to put in the chat. Everybody clear? Everybody good? This is from the National Association of Realtors. I think they did a good job on safety. So here's the link. I just put it in the chat. You can click on it. Let's take our break. When we come back, we're going to talk about safety. Everybody good? All right. We back? I got a third fan on me, so I'm trying to get I don't think I have any more fans left in this house. Goodness. All right. Camera's on. Did you guys, the video play okay? Did everybody see it? Everybody got to watch it? All right. So we're going to have I know there's some questions about safety, but we're going to have a conversation. Guys, please remember, safety is not a testing topic, but safety is important. So cameras are on, and I am taking attendance. So let's talk safety. First off, when it comes to safety, the number one question I get is, can I carry my gun? So first off, you have to have a concealed carry. Okay. You have to have a concealed carry if you want to conceal carry a gun. Your firm policy may or may not dictate if you can have your concealed carry. So check with your firm policy when you join. If guns aren't your thing, or if your firm doesn't allow you or chooses not to have your concealed carry, there are other forms of protection out there. You can get mace, you can get, your car keys can be protection if need be. Anything can be a weapon in a situation. So guys, I don't want to scare anybody, but the truth is you're opening yourself up to the general public. And not everybody in the general public has good intentions. So you always need to be safe. You always need to make sure that you're protecting yourself. I think every single one of you should take a self-defense class. I think every single one of you should take. They're offered all over the place. You don't have to drive around far to see a banner, self-defense offered here. You can get a group of friends. Maybe somebody in your firm can go with you or not. But self-defense, how can you get away from an attacker? Getting away is going to be your priority. So you can learn some certain moves of self-defense. Always know who you're dealing with. I strongly discourage any of you from meeting a stranger at a vacant, empty home. So when you're on phone duty and somebody calls you and says, I'm sitting in front of 123 Main Street, can you drop what you're doing and come see me? Come show it to me. It's easy to be led by dollar signs, but I need you to put your safety first. If you don't know this person, insist that they meet you in a public place. If it's not convenient for them to come into your office, take them for a Starbucks, take them out for a Panera, get them somewhere in a public place where you can sit down and have a conversation with them. Do your working with real estate agent, maybe have an excuse to do that. If they're not willing to do that, then I have to question how serious they are about 123 Main Street. Guys, there is no amount of commission worth your safety. No amount. And if you don't believe me, then ask your family on the next break. I'm sure they'll back me up here. The video mentions, and I think some agents have the practice of having their having their people before they meet them, text them an image of their driver's license. If you can't copy it at the office, then you can, have them text you an image, take a snapshot with your phone or something. But just having that, if they're not willing to do that, then I have to question how serious they are about the transaction. So know who you're dealing with. We have a phenomenal tool at our disposal called Google. So you can always do a quick search on someone if you don't know. But again, I would try to get it from them, get their driver's license. Make, model of the car as well. Know who you're meeting, what car you're looking for, right? Make, model of the vehicle. Tell someone where you are and who you're with. May it be a coworker or a family member, but let somebody know your whereabouts. Back in the day when it was a different market and you could go out with buyers, you could spend all day on Saturday with buyers showing them 13 properties. And you have your agenda, you have your itinerary. my husband always had our itinerary. So he knew about what time I was going to be at which property. I hate to say this, but if you ever go missing, if they can track you down to where you're supposed to be, they have an easier time of finding you more quickly. So let somebody know where you are. If you're doing an open house, let somebody know what open house you're doing. We'll talk about open houses in just a second. Keep your phone close. If you're doing an open house, for example, I always know where my dead spots are. Like if I don't have a signal in the basement, I'm not going in the basement, right? So you can always have an idea of where your dead spots are, but keep your phone close. I don't think you guys will want to be on your phone while you're with buyers, but if you have it handy, you can even have 911 pre-programmed if you want, so you can get to it more quickly if need be. Open houses are there's several things going on with safety for open houses. First off, let's talk about your seller. You're opening the front door for anybody. Maybe they're an interested buyer, maybe they're kicking tires, maybe they're scoping the joint out. There was a case a couple years ago. There was a couple going around open houses in Winston-Salem, and they were stealing the ice cream from the deep freezers. So they were going in and looking for deep freezers and taking the ice cream and smuggling them out. And I don't know why, but it was happening. And agents started talking and they were realizing that they were having these same things. So we need to have our sellers keep their stuff secure. Let your sellers know at an open house, you may not be able to follow everybody around. You may not be able to with everybody at all times. You know, if you have a successful open house, you could have multiple groups in at the same time. And you can't be with everybody at once. So your sellers, anything that can slip easily into a pocket, weapons, medications, jewelry, anything like that, they need to lock up. Don't put it in the medicine cabinet, but lock it up. Remember what we said, if it's going to convey, the buyer has the right to look. So can the buyer open the closet door? Yeah, because they come with the closet, right? Don't they have a right to see what inside the closet looks like? So tell your sellers not to put stuff in kitchen cabinets. Remember earlier I said we went to the educators conference and they always tell us complaints from the previous year. Last year, they got a ton of complaints. They have buyers and agents on video taking prescription medications. It's hard to argue against a video. Guys, it is 2022. And if you're not conducting your life as if you're on camera, you need to start, because there's a really good chance, especially if you're in somebody else's home. So prescription meds, sellers need to put those up. They need to put them somewhere that buyers can't access. Your sellers, when you list the property, your sellers should be depersonalizing the home anyway. It's hard for a buyer to imagine themselves living there when they're looking at pictures of your seller's kids. So have them depersonalize anyway. They got to move, right? Why not start packing up some stuff? You know, we always used to say, I'm trying to sell space, not stuff. So if you can get rid of some of the clutter, then that's going to help me show the space. That's going to help me show the stuff. But the other thing could be for their safety, so things don't walk away. So the sellers are one piece of an open house. The agent is the other piece of the open house. It's really funny if you think about it, but we're kind of sitting ducks, aren't we? We advertise to the whole world, hey, I'm going to be at this big empty house by myself from 2 to 4 on Sunday. Come see me. So we're letting the world know we're going to be there. So you've got to take some precautions at open houses as well. Have, you know, a weapon, something on you. For me personally, when I'm doing an open house, I don't leave the front door. I keep myself positioned at the front door. I greet buyers as they come and go, but I keep myself stationed at the front door so I can see who's coming. I see you coming down the street long before you ever get there. I'm aware of who's coming in and out of my open house. Again, you know, before I open the house for the open house, I walk around and see what dead zones I may have. So if I do have to leave my position, I know where not to go, where my phone doesn't work. So when they say, hey, Julie, can you come down and look at the basement with me with something? No, I cannot, so just, you got to be aware, you got to think. Did I just mention? I don't remember. I have my concealed carry, but I don't have my gun in the open house. I have it nearby. Don't worry. I keep my mace in my pocket. My whole objective is to get away. I got my panic button on my car key if I need that. But we need to, again, have the sellers remove the risk of temptation, and then you have got to protect yourself as well. You can have somebody do the open house with you. They don't have to be licensed. So if you want your significant other or, BFF to come do the open house with you, that's fine. You just need to have the conversation with them up front that they understand their role. They are there to be safety in numbers for you. They are not there to sell the house. So when the buyer comes in and starts asking lots of questions, your unlicensed friend needs to get them back to you. Does that make sense to you guys? They can be there, but you need to make sure that they understand their role. Even showing property. If you do have to meet somebody at a vacant home for the first time, take somebody with you. Take a coworker. There's been some evenings before that I've taken my husband. He stayed in the car. He didn't get out of the car, but he was there and they saw him. So, safety in numbers always. Your office policy will probably have some kind of safety, or office will have some kind of safety policy, distress code. So if you need help, you should be able to call peer to help. I know, for example, my team uses WhatsApp. We communicate on WhatsApp, and you'd send a WhatsApp and we're responding right away. So if somebody was in distress, we could get to them. Your personal marketing, you guys are going to have to write profiles. And connecting with somebody online is tricky, right? You're trying to form a connection just by them reading your profile. So you want to be descriptive. You want to talk about yourself because you're trying to make that connection, but you don't want to make it too personal. Absolutely never, ever, ever give your home address in your marketing. Use your firm's address always. I think it's okay to talk about your kids, but don't be too specific about your kids. I think if you have children and the potential buyer has children, that's one way to make a connection. But I would just be very careful about the information you put out there on your children. Dress for safety. Ladies, I think this especially applies to us. I would caution you from wearing high heels, stilettos, that kind of thing. You want to be able to get away. It might be hard to run. What if we just had a whole bunch of rain? The yard's now a little soggy. At some point, you're going to be walking the front yard or the backyard, not once you get stuck in your heels. So I would suggest dressing for safety. Something, again, your objective is to get away. So you want to make sure that you don't, flowing things, for example, scarves or stuff, somebody could grab that as you're trying to get away. Don't allow yourself to be blocked in. Again, this is twofold. This applies to rooms in the house. So if you're showing property, you let the buyer lead. Think about this. We can do this, two objectives. Let's say the primary bedroom's on the second floor. The only way out of the second floor once you walk in is the second story window, right? So you let them go into the primary bedroom first. And you say stuff like after you. It also helps the buyer see the home. It's really hard for the buyer to imagine themselves living there when I'm standing in the middle of the room going, here you go. What do you think? You guys with me? So kind of use it as their benefit, but I don't want you guys to get stuck in. Don't go up and down the stairs first. That's a trip hazard right there. Let them lead. The second piece of this is where you park your car. If at all possible, park on the street so you can get away if need be. Now, if there's no street parking and there's only a driveway, there's not much you can do. I understand that. But if all possible, park in the street. And the last thing, and I think these two are the most important. We always need to be aware of your surroundings. When we get out of the car, your buyers are looking at curb appeal. They're looking at the lawn. They're looking at, you need to be looking at what's going on around the neighborhood. You need to be observant. Is there somebody around that makes you feel uncomfortable or whatever? You need to be aware of your surroundings in the yard, in the neighborhood. And I think the best piece of advice we can give you when it comes to safety is to listen to that little voice in your head. That little voice is there for a reason. And when that little voice tells you to get the heck out, don't question it, don't argue with it. It's telling you to get out for a reason. And that's your biggest defense, hands down, right there. Somebody just came into the chat and asked if I've ever felt, I mean, I've had one incident that I would even barely call it an incident, but it was enough to make me revisit my safety procedures. I was in an open house. And after that, I was a lot more cautious, and it was very early in my career. So I'm kind of glad that the barely incident happened when it did, so it could make me be better prepared for the future. I've known agents that have had more than an incident. They've had an actual incident. And again, I'm so grateful that they made it out. Guys, unfortunately, there are cases every once in a while where agents are harmed, sometimes even killed from the buyers or sellers at their meetings. So this is why your safety always needs to be first. It always needs to be a priority. There was an agent in Arizona that was raped and murdered by a potential buyer in, it must have been September. And the reason I say that is because NAR recognizes September as Agent Safety Awareness Month. So it's a good time for us to revisit our safety policy, for us to, in remembrance of her, to revisit our safety policy and make sure that we're practicing that protocol. Remember what fair housing taught us. What we do for one, we do for all. So if you ask for one buyer's copy of one buyer's driver's license, don't you have to ask for all? Isn't that only fair that you treat everybody? So this is why it's important that you guys create your safety policy early. Your firm will help you. Create your safety policy early, and then you follow it every single time. Again, there is no amount of commission worth your safety. It's not worth it. And you guys, especially brand new, I get it. You get that phone call and that buyer says, I'm sitting in the driveway. Can you come show me the house? And it's so easy to want to run out there and show, because you think you got a sale. Maybe you do, maybe you don't, but you got to slow down and think about safety before you meet this complete stranger at a house that was there before you. I need you guys to think it through. Seriously, I need you to think it through, and I need you to follow your safety procedure and your safety protocol every single time. That's right, situational awareness. If you see something, say something, so you can help other agents out. There's several, if you're in the Triad MLS, we have several like closed Facebook pages. I'm sure there's others too. That's how we all learned about the ice cream bandits, because we were talking about it on our closed Facebook group. There was a buyer a couple years ago that made several agents feel uncomfortable. And we were talking about it. We were letting everybody know, you know, just be wary. Not saying don't work with them, but just proceed with caution. Make sure that they have their best interest in mind and that they are not out to harm you. Is this something you guys have thought about, getting into real estate? I mean, like I said, you're opening yourself up to the public, and the public includes all walks of life. So you guys just need to make sure that you're taking care of yourself first. Let's see. If I was in the house and felt like something was wrong, should I just leave? I would at least get in my car. I don't know if I have to legally lock them up. I don't know that I would lock them up, but I would feel a lot safer in my car with the doors locked, making a phone call than I would trying to, you know. Yeah, and that's right. It's just good for everyday life. Just follow safety. Guys, I don't know. If you're like me, you're getting to the point where you can't look at the news anymore because there's always a shooting or a stabbing or a fight or something. And it's hard to look at the news anymore. Wake up. This is all around us. So even when you go to Walmart this afternoon, you need to be aware. You need to listen to that little voice in your head. You need to pay attention, This does not just apply to real estate. What questions or comments do I have about safety? I knew an agent once, buyer called her to see some land, and he sounded very serious on the phone. And she met him, and the land was like down this dirt driveway somewhere, like way off the road. And once she started driving down that dirt road, she got this uneasy feeling. That little voice in her head was screaming. And she saw him standing there waiting on her. And she came up with this, oh no, family emergency, I got to go, turn around, and got out of there. Well, then she started second guessing herself. Oh, don't I feel silly? I'm sure he wasn't going to mean me any harm, et cetera, et cetera, et cetera. He called back and said, I hope everything's okay. You know, when you're available, I still want to see this land. And so she again started second guessing herself. This guy was serious. So she said, okay. And they made another appointment to go out. The second time, her husband said, I'm coming with you. Thank God for her husband. She pulled up the second time. He looked around for 2 seconds and said, no, I'm not interested, and left. Was he serious buyer? I don't know. Did he get scared off because he saw her husband? Those are questions you can never answer. But you know what I do know? The little voice in her head was screaming, and it was there for a reason. Maybe, maybe not. You guys with me? You got to pay attention to your instincts. What questions do I have on safety? Comments? Again, I'm not opposed to concealed carry as long as you're comfortable with guns. Not everybody's comfortable with guns. If you're not comfortable with a gun, please don't get a gun. You're only going to hurt yourself or somebody else innocent. There are other forms of protection out there you can get. Anything can be used as a weapon. We good? Nobody has anything to say about safety? I haven't scared you guys, have I? That's not what I want to do. I want to make you aware because I want you to be safe. I want to protect you. Just a couple things, a couple reminders, and learn, test, pass. In the welcome section, first off, in the welcome section, here's our syllabus. Remember, this is your guide when you're preparing for the state exam. Okay, so when you're getting ready for the state exam, this whole class was written with this syllabus in my hand. So everything we talked about could be a candidate for your state exam. Okay, so once you guys pass my class, this is your guide. Your relink book is the, yay, I passed Julie's class. Now what do I do? So how do you submit your application? How do you apply for your background check? How do you apply for your state exam? What do you do when you get your license? It's all covered in the relink book. And then as we mentioned earlier, there's this letter. You guys are finishing up my class, possibly taking your state exam during the renewal period. The renewal period started Monday. So there's certain things you need to be aware of. Those that pass prior to July 1st, those who pass on or before May 31st. It'd be hard to get this one, but you very well may fall into this one. So if you're going to go to the state exam soon, you need to pay attention to this letter, know what it says, what to expect. Those things are all in the welcome section. And then when we fast forward to the bottom, for my exam on Thursday, I provided you guys with a review. No, that's not it. It's called the review. I've provided you guys with a review, with the end of course review. And this is what you can use as your guide to prepare for my exam on Thursday. So if you haven't looked at this already, I highly suggest that you do. Be aware what's on here so you know what to expect. This does also apply to the retake. So if you're eligible for the retake, and we'll talk about that in just a second. If you're eligible for the retake, you can still use the guide. I'm getting ready to do exam rules and expectations in a second. You guys looked at this yet? Have you guys looked at the review? Some of you? You got a whole day and a half, so you still have time to, if you haven't seen it yet. But it's called the end of class exam review. So I think the name kind of says it all. Learn, test, pass. Okay. How are we? Everybody good? I'm burning up. I miss my AC. All right, y'all want a Kahoot? Y'all, this is going to be our last Kahoot. Oh my goodness. Oh my goodness. Let's Kahoot. This Kahoot is on license law and commission rule. So this is the Kahoot, the page 707 material. And then the rest of the license law and commission rule that we had to go pick up. So you're either on the website or the app. If you're on the website or the app, it's going to ask for a game pin. Or you can scan the QR code. If you scan the QR code, it'll bring you right in. Is that honey? Flying to the beach. I can dig that. That's right. Pancakes? I can dig that too. You got 30 more seconds to get in if you want to play on your phone. Okay, everybody ready? Everybody in that wants to play? All right. License law and commission rule. Question number 1. North Carolina Real Estate Commission may take disciplinary action against a licensee who ten seconds. Both violated provisions of license law and has been disciplined by another professional license. So assuming you have an active license in the state of North Carolina and you get disciplinary action by the South Carolina Real Estate Commission, they may take disciplinary action against you. Maybe they will, maybe they won't, I don't know, but you've got to report it. How many days do you have to report that conviction? How many days? 60. So remember, that's a violation of a convicted felony or misdemeanor. It's also a violation if you get yourself in trouble with your other licensing board. You have got to report it. Kind of a trick question, but I kind of like that. What questions do I have on this? Everybody good with that? 60 days to report convictions or disciplinary actions from another licensing board. Are you going to get in trouble? I don't know. You will get in trouble if you don't report it. Okay. So let's see who got it right the fastest. Quick to the draw. Tio, up first, Rhea, Sav, Kristen, and Aaron, out the gate. Question number 2. Real estate license must be renewed no later than every ten seconds. We renew every June 30th. The renewal period is May 15th to June 30th. What do we do during the renewal period? How do we renew our license? How do you renew? You show them the money. You show them the money. You send in, again, this year it was $45. How much is it going to be next year? I have no idea. But this year it was $45. So you renew. Failure to pay by 11:59 on June 30th means at the stroke of midnight on July 1st, your license is expired. So we got Aaron climbed up, Sav, Rhea, Devin climbed up, JJ climbed up. Laura P's our highest climber, up 9 places this round. What is the deadline for continuing education? Ten seconds. Deadline for CE every year is June 10th. You do CE by June 10th, you renew by June 30th. Very important dates. The deadline for CE every year, even during COVID, the deadline was June 10th. They would grant an extension. 18 months from licensure is how long you have to complete post-licensing. I know I'm recording, so I got to be careful. They're a little obnoxious about the June 10th deadline. You're going to know that it's time to do CE. It's all over their homepage. There's emails, your BIC. My gosh, I'm so tired of my BIC reminding me. I said, I did my CE 4 months ago. Are you kidding me? So they are all over you about doing your CE the June 10th. They are not going to remind you your 18 months. That 18 months is up to you. So the day you get your license, start your 18-month clock, and that's for post-licensing. Questions on this one? June 10th, June 10th, June 10th, June 10th. This date should be up there with like your birthday. Very important date. So Aaron stayed up, Sav and Rhea, JJ and Devin switched places, it looks like. Steph's our highest climber this round, up 4 places. Question number 4. In North Carolina, all real estate brokers must, all must. Eight seconds. North Carolina, all real estate brokers must include the name and the ad of the property for sale, the firm's name. Otherwise, you have a blind ad. So we have to have a blind ad. What's wrong with the blue one? This is why I like this question so much. What's wrong with the blue one? Anybody can unmute yourself and tell me if you want. I want to hear somebody say it.
Active?
Not active.
Currency? Current means
Current.
paid.
A current license has nothing to do with education. A
Money.
current license has everything to do with money. So taking your CE does not give you a current license. What gives you a current license? Show them the money, pay the fee. You see how they like to do, you guys? This isn't me being mean. This is me showing you guys what they like to do. That word current is very important. What questions do I have on this one? Tricky, tricky. So we got Aaron staying on top, JJ and Rhea, Flip Flop and Kristen popped up, Carlene. 7 of you are on fire. You have an answer streak of 3 in a row. Question number 5, under license law, a provisional broker is authorized to ten seconds. Under license law, a provisional broker, look at you guys go. This does my heart good. You can list a property for sale as long as what? You're under the supervision of a broker in charge. A provisional broker can do just about everything that a PB. You have to advertise under your name, and nobody, I don't care who you are, nobody can sign on behalf of the client. PBs can only accept commission from who? Can you accept commission from anybody, payment from anybody, PBs? Nope, just your supervising BIC. That's the only person that can pay you. Questions on this one? Aaron, Rhea, and Kristen are coming up. JJ, Carlene. Wade's our highest climber this round at 4 places. Last one. How long for receipt does a PB have to deliver trust funds to their BIC? Four seconds. I lost track. How long? You got to deliver it immediately. Why? Because provisional brokers can't walk around with somebody else's money. So when your client hands you a check as a provisional broker, you must get it immediately to your BIC. As a full broker, you should, right? Because remember, when it's in your hand, it's your responsibility. Never deposit somebody else's money into your account for safeguarding. That's trust account violation all day long. And then the 3 days of receipt, 3 days of contract formation, those are the rules that we have for depositing the earnest money into the trust account. Must deposit 3 days from receipt or contract formation, whichever one comes first. Questions on this one? All right. Let's see what we got. Our 3rd place winner this round is Kristen. Good job. Our 2nd place is Rhea. Good job. And our 1st place is Aaron. Good job. And then our runners up, we got JJ, and looks like our little person's getting a massage there. Questions? We're going to take, hang on, we're going to take a break. When we come back, the very last thing that we have to do is the rules and expectations for the exam. I need you guys to be here, paying attention and listening, because failure to follow the rules and expectations for the exam may mean you lose your exam. Do you guys want to lose your exam? No. So I need you guys back in 10 minutes. Can I get everybody back in 10 minutes, please? And I need you here, focused and paying attention. So let's take 10. When we come back, we're going to have a very important discussion about how I conduct my exam. All right. We back? Very important discussion. Does it feel like just yesterday I met you guys for the first time? It amazes me how quickly this time goes by. And yet here we are. All right. I need to see you. So a couple of you, I'm looking at ceilings, I'm looking at walls. I need you guys to adjust your cameras. Stephanie, is your AC out too? I feel your pain right now.
I can't get the air conditioning right in our house here. It's like it goes from just super cold into too hot, and I'm like, oh my God.
Call
But
your
then
guy now, because that's the problem we started with, and now I'm in the situation where I got nothing.
Oh well,
Call
I
him now.
like phone cooling because it has a unit for each room. So
Gotcha.
I'm still got a learning curve. We bought this house back in January, and this is kind of my first summer in it. So
Still learning. All right, let's see. Can I see you? I am taking attendance. All right. Your exam on Thursday. That's a good idea. A window unit for emergencies. Yes. All right, guys, this is one of these discussions. I'm going to ask that you hold off on all questions until the end, because there's a really good chance I'm getting ready to answer your question. So if I can just ask that we hold off all questions, I got plenty of time for Q&A. Anybody else feel this guy's pain right now? I love this guy. You guys know what he's going through? Yeah. All right, real estate exam. First off, remember, we've had the discussion. I've been asking that you all are in a distraction-free place on Thursday. So you're in the room by yourself. No family members, no pets, no kids. It is just you and your laptop, okay? If I think you're having a conversation with somebody else in your room or the house, the commission says I need to take your exam. And I have never had to take an exam, and I really don't want to start on Thursday. So everybody good with that? Do I have any questions about that? Distraction-free. How many distractions are we allowed to tolerate? 0. If you have any concerns about what distraction-free means, you need to call me like today. Okay, everybody good so far? All right. So what's going to happen on Thursday? We have to do a check-in process on Thursday. I'll talk more about that in just a second. I'm going to log on at 8 a.m. Thursday morning to start the check-in process. I got to have a little one-on-one time with each of you. If you guys can log in early, I got to get everybody checked in before we can start. So on Thursday, I'll be on at 8 a.m. I need you guys to plan to log on early so I can get you checked in. And I can't get you checked in until I can't start until I have everybody in. So please plan to come early on Thursday. Again, one-on-one time with me. I need to see various things that we're going to talk about on the next slide. I'll be in at 8 a.m. So yes, you log on to Zoom like you always do. Okay, log on to Zoom like you always do. That part's not changed. I can't have all of you waiting until 8:45 though to come on, because there's 47 of you, 48 of you, and 1 of me. Okay, so that's why I'm going to be in at 8 to start getting you guys checked in. For the check-in, but how early do you need to be? You can come on anytime after 8 a.m. If you come in at 8:57, you're going to delay your peers. So if I could have you guys come on 8:15, so we can get it. Okay. For the check-in, it's show and tell. I need to see your basic calculator. I cannot let you use your phone. I cannot let you use a calculator on your laptop. So I will need to see your basic calculator, and that there's nothing, no cheat sheets on your calculator. You can have a pen and a pencil. You start with 2 pieces of scratch paper and only 2 pieces of scratch paper. If you need more, I'll let you get more. We'll talk about it in a second, but we're going to start with 2. Why 2? Because this is what PSI tells you to start with. This is what PSI starts you with. So again, I'm trying to prepare you for your state exam. I need to see your blank scratch pieces of paper front and back. I need to see that they are blank. Once the exam starts, you can do whatever you want to with your scratch paper. Write your formulas, write old car, whatever it is that you're storing, but you cannot write on your scratch paper until the exam starts. If at all possible, I need to see your space. If you're on a laptop, you can show me that you don't have, your nice clean desk. If you're on a desktop, you can't show me. So if you're on a desktop, you're pretty much putting your right hand up saying, Julie, I have nothing on my desk that could constitute as cheating. I'm going to have to take you on your word. So if you can show me your space, we'll have this discussion in our one-on-one. I'll let you have drinks and snacks and cough drops and gum and mint, whatever you need. I'll let you have any of that. Also during the check-in, I need to see that your notebook and your textbook are nearby and closed. Some of you have a shelf or a ledge behind you. If you can put them back there, that's fine. If nothing else, you can say, Julie, here's my textbook and I'm putting it right here. I need to know where your book is. Why? Because I allow you guys to take bathroom breaks. And I need to make sure that your book is not in the bathroom. I need to make sure that your notebooks are not in the bathroom. So I need to know the location of your books and notebooks. So you're going to show them and you're going to say, Julie, I'm going to put them right here. I need everybody's phone off. Do we all understand the difference between off and silent? Okay, I need it off. This is what I'm learning in my exam. Somebody a couple exams ago got the clever idea to actually show me that they're powering their phone down. The problem with that is we very rarely turn our phones off and we don't know how to do it. So that takes a lot of time, me watching you power it down. So if you can power it down before and you hit buttons, if you hit a button, you see how I can see that it's lit up. So save us some time in the check-in process and hit a button and show me that it's off, as opposed to us taking the time to power it down in class. And practice turning it off. That's one thing I learned is we never, ever, ever turn our phones off. So how do we do it? I don't know. Again, I need to know that your phone is with you and off, not in the bathroom. Scratch paper stays blank. Even after you're checked in, your scratch paper stays blank until the exam begins. Once I have you checked in, you're in and your camera stays on. Questions on just this, the check-in process, what I need to see, what I need to verify. This is our one-on-one time. We're each going to have a little conversation. This is what takes the time, and this is where I need you guys' patience. I'm going to go ahead and thank you in advance for your patience. If you come on at 8 o'clock, I appreciate you coming on at 8 o'clock so we can get going, but I just need your patience. There's a lot going on before I can give the exam. We're pretty good about this, I think, for this class. No virtual backgrounds, no dimly lit spaces. I need to be able to see you. So that's why I think everybody, let's see, a couple of you have a filter on that makes your background look blurry. I'll just need you to turn that off for test day so I can see clearly behind you. Somebody's camera just popped off. So there you go. And you will need to have your camera down. I need to see you and not your wall. So that's why I wanted to make sure I could see everybody now. So I need to see you, watch you the whole time. When the exam begins, there's only going to be 2 tabs open on your computer. You're going to have Zoom so I can see you guys. I'll show you in just a minute what you can do to minimize your Zoom so you're not distracted by others. Okay. The other tab you have open is Class Marker. That's the link to your exam. Once I get everybody checked in, I will give you the link to Class Marker. So you have to open your email to access Zoom. Once you're on Zoom, you shut your email down. Again, this is the honor system, you guys. You have Zoom, and then once I provide the link, you have class marker. And I'll show you again in just a minute where you can minimize Zoom so you're not distracted by your peers. I'm watching you. I don't need you guys watching everybody else. I need you guys focusing on your tests. By the way, I will have help on Thursday. Anika Bartley, you guys, she teaches post licensing for Carolina School of Real Estate. So once you guys get into post, you'll meet Anika. Anika's going to be watching with me, helping me monitor, helping me observe, so we can make sure everybody's on the same page. When it comes to communicating during the exam, I am your only friend. I'm it. I'm sorry, but I'm all you got. I am the only person you can communicate with. And the only way you can communicate with me is via direct message. If you unmute yourself, you've distracted others, and I've never tolerated distractions, even when we were in person. Some of you have worked really, really hard to be here, and I'm doing everything that I can to eliminate distractions. So if you need to communicate with me at all, you're doing so by direct message. So why would you need to communicate with me? If you're leaving in front of your camera for any reason, if you have to go to the bathroom, tell me in a private chat. If you have to go adjust your thermostat, tell me in a private chat. If you have to go turn the light on, I've heard it all now, tell me in a private chat. If you need more scratch paper, tell me in a private chat. If you're leaving in front of your camera for any reason, tell me in a private chat. I'm your friend, and I'm all you got. What questions do I have on this? This is part of the reason why I've been practicing with private chats. See, I've been building you guys up to this. Everybody know how to private chat with me? Okay. What if you lose power? What if you lose internet? First off, do I have any control over your power or your internet? Not that I figured out. So what if? Guys, things may happen. The internet may go out, the power go out. Right before I give you the link for class marker, in the chat, I'm going to put my phone number. And right before we start the exam, you guys are going to write my phone number down on your scratch piece of paper. So it's blank. I give you my phone number, and then you start the test. Everybody with me? If anything happens during the exam, you can turn your phone on and call me, text me. Trust me, I'm going to be sitting right here with my phone in my hand. If anything goes wrong, if anything happens, I don't have a crystal ball. I can't tell you what can go wrong, but what I do know is we will get through it. We've had internet issues previously in tests. Guys, remember, we've been doing this 2 years now. This may be new to you, but we're old hats at it at this point. So if you lose connection, if you lose your exam for any reason, we will get through it. You just have to reach out to me and we'll get through it. Let's see, do we have to wait for my response to ask to use the bathroom? That's a great question, and I appreciate you asking me that, because sometimes I'm trying to communicate with somebody else and then you're trying to tell me you're going this right, so I might just not be talking to you. So no, you don't necessarily have to wait for my response, but I do need to know, I do need in the chat why you're leaving your camera. So thank you. Question comes in, can we leave the camera after check-in is complete but before exam starts? As long as you tell me in the chat. Again, once you're checked in, you're in. So when you're in, if you want to go get another cup of coffee, you just got to tell me in the chat, Julie, I'm going to get another cup of coffee. Your camera stays on. Somebody's camera just now popped off. Your camera stays on once you're checked in. If you leave your camera for any reason, you tell me in a private chat. Yes, I just said that. Yes. And I don't know what all can go wrong, but trust me, I know we will get through it. We will get through it. Isn't that good advice to tell your buyers and sellers to think about that? I don't know if you're going to close or not, but what I do know is we will get through it. So the exam, once I have everybody checked in, I'll put the link for class marker in the Zoom chat. You click on the link, class marker opens, you start your exam. If you have not watched the class marker tutorial yet in your email from Lane, please do so before Thursday morning. You get 3.5 hours for your exam. Passing is 75%. I'll talk a little bit more about that in a second. You'll see your results immediately. You say submit, and it says, are you sure? And you say yes. And it says, boom, pass or fail. It's like that. It's like that fast. I'm telling you to hang on to your hat, because when you're done, you're done. On the one hand, that's good news. On the other hand, you don't have to wait. You click on the link, you put in your name and your email, and then it takes you to something that looks like this, which basically says that this is a closed book exam. You're not going to use anything to cheat, notes, electronic devices. You guys cannot discuss this exam with anybody. Lane or I may be the exception. You guys cannot talk about this exam afterwards. I don't know if we have any study groups out there or not. But you guys cannot discuss this exam after. That would be considered cheating. Once the exam starts, I cannot answer any more questions about the material. I get that a lot. Julie, what does this word mean? Once the exam begins, you guys have had access to me since like March. That goes away when the exam begins. So ask all your questions today, tomorrow. I'm around, I'm available. So you're going to read this, and I need you guys to read this on Thursday. You're going to read this, and then you're going to click on start. By starting the exam, you're agreeing to the terms. You're agreeing you won't cheat. You're agreeing you won't communicate. You won't use any devices, anything to help you. On your exam, you see one question per screen. If you read a question and you don't know the answer, you can bookmark it so you can go back to it. I always suggest you guys bookmarking the math. Save the math for the very end. The math is going to take you the longest. So if you save the math for the end. Also, if you read a question and you say, oh my God, I have no idea what that is saying, bookmark it and come back to it when you have more time to think about it. So if you read a question and you don't know the answer, bookmark it so you can go back to it. Question came in. If you don't bookmark it, can you go back? Of course. Again, I encourage you to watch the tutorial from Jane. Each page also has a link on it that says see all questions. And your questions are either going to be answered, unanswered, or bookmarked. So you can watch you can click on that see all questions and kind of watch your progress as you go, see what's answered, see what's not, and see what's bookmarked. If you have anything unanswered, yeah, guys, guess. If you guess, you got a 25% chance. So guess. If you have something bookmarked, that's ones you can go back to. The very last thing you should do before you submit your exam is click on see all questions and make sure everything says answered. Is everybody with me? The very last thing you should do is click on see all questions and make sure every single one of them says answered. You also have a countdown clock. I don't want you guys staring at the clock, but you need to keep half an eye on it. You got to watch your time. Hopefully you've been practicing working with a clock. Keep half an eye on your time. I will, with about 10-15 minutes left, I will unmute myself gently so I don't startle you, and just have you be aware of your time. I don't want you guys to run out of time. So I will unmute myself and tell you guys to watch your time. When you pass, Lane will be in touch with further instructions. Lane will send you your certificate of completion. The certificate of completion is the last piece that you need to complete your application to the North Carolina Real Estate Commission. There's information on that certificate of completion. Keep the email from Lane. Even if you're not ready to submit your application now, keep the email from Lane if you're ready a month from now, 2 months from now, And check your spam. Sometimes Lane winds up in spam. I don't know why, but check your spam. Make sure you get this email from Lane, and then keep that certificate of completion. 75% or more is passing. If you don't pass, but you at least make a 50%, you are eligible for the retake that is on Tuesday, May 24th. Lane is going to give you guys your retake. So if you're eligible for the retake, Lane will send an email with her Zoom link and her instructions about what time to log on. How early she needs to log on is just going to depend on how many of you are eligible for the retake. Does that make sense? So if you're eligible for the retake, you're going to get an email from Lane. If you don't make a 50% or more, you're going to get an email from Lane. One way or another, you're going to hear from Lane. Pass, eligible for the retake, or not eligible for the retake. Guys, please be patient with Lane. Lane's a busy girl. Give her a minute to email you. Give her a minute to respond. It blows my mind how many students call Lane at 1:30 and say, I passed and I haven't heard from you yet. Well, holy crow, man, it's been like 30 minutes. Maybe the girl wants to eat lunch, right? Just give her a second. Be patient. She'll get with you. I trust you. Okay. Let's see, 112 questions. 112 questions on both my exam, the retake and my exam. You have to get a 75%. Pass, fail, or eligible for the retake. Lane will be in touch. Just please be patient with her. What questions do I have about your exam? What questions do I have about Thursday? Again, the class marker tutorial is in that email from Lane. If you haven't looked at it, or even if you did, it might have been a couple months ago, but it can't hurt. And that kind of walks you through so you know what to expect class marker to look like. Certificate of completion has the rest of the information that you need to submit your application. A question came in, do we know what we got wrong? No, because we can't discuss the exam, so I can't share that with you, but you will get a report that tells you the percentage. So it'll tell you you got 80% of agency right and 30% of contract. So that can kind of help you know where to focus your energy. So you will get a report of the percentages of topics that you got right, but we cannot share your exam. Pass or fail. Thank you. That's a good question. Pass or fail. We can't go over the exam with you. That's the Real Estate Commission. Other questions about the exam, the retake? May I offer you guys some suggestions? You guys want tips and tricks? Make sure I don't have any other questions first. We all good on the rules and expectations? Please don't be the first class that I have to take a test from you. Then you become a story in my pre-licensing class, the next one and the one after that. Don't become a story. All right, what can I do to help you guys? The best piece of advice I can offer you is to breathe. I need you guys taking big, deep breaths. Don't, not short labor breaths. If you look at a question, you go, oh my God, I've never seen this before in my entire life. Stop. Take a big, deep breath. I promise you, when you're centered, things make a lot more sense. So if you feel yourself getting worked up, just take a second. Close your eyes if you have to. Sit on your hands, but just take a second and take a few big, deep breaths to get yourself centered again. Okay, breathe. Remember to breathe. So important to breathe. I need you guys reading the question and the answers. It's part of the reason why I've been encouraging practice questions. Every single word means something, not just in the question, but in the answers as well. So read and breathe, breathe and read. Doesn't that kind of rhyme? Read and breathe and read. How many of you are guilty of this? Do not change an answer unless you are absolutely sure. Has anybody ever changed the right answer wrong? Come on, come on. Have y'all learned your lesson yet? Stop it. Do not change an answer unless you are like 5,000% sure that it's wrong. Back in the day when we were in person, Lane and I had to grade paper tests. And I can't tell you how many times I saw right answers change wrong. I can't tell you how many times I know people that failed this exam because they changed too many answers. Do not change an answer unless you are like 5,000% sure that it's wrong. Make sure you answer anything skipped. Click on that see all questions and make sure they all say answered or unanswered, or you want to make sure they all say answered. Make sure none are bookmarked and make sure none are unanswered. As we said, I think you guys should save the math for last. When you get to a math problem, bookmark it. The math is going to take you the longest. When you get to a math problem, you bookmark it. And then in the end, you know how much time you have left. You bookmark anything you don't know. You bookmark something you need to spend more time on. I don't want you guys running out of time. Speaking of time, take your time, but watch your time. You need to keep half an eye on your time. Watch your countdown clock. And if I unmute myself and say, y'all got about 10 minutes, then you need to make sure that you get the unanswered questions answered. Don't leave anything blank. Have you guys learned that in practice test 2? Maybe you read a question and you don't know the answer, but then you have a question, maybe 3 questions from now, and there's something in that question that triggers something from the question you skipped. Have you guys had that happen yet? So maybe if you bookmark it and don't answer it, if you keep going, then something later may trigger that for you. It might help you. So again, if you read a question and you have no idea, bookmark it so you can come back and think about it. So you can come back and spend time with it. Kahoot questions, I think, are like 30 seconds generally. I think, I don't know. Kahoot questions are shorter and not as in-depth. I got a character limit in Kahoot. There is no character limit on your final exam, okay? Always remember to focus on what the question's asking you, help you rule out distractors. So what happens between now and Thursday morning? I need you guys to study, yes, but what I don't need you to do is spend all of your waking hours studying. I don't need you guys up all night Wednesday night. Don't try to pull an all-nighter. At some point Wednesday night, you've got to put the book down and relax and get a good night's sleep. At some point Wednesday night, you have to know that you know what you know? So at some point Wednesday night, put the book down, have some family time, quiet time, take a bubble bath, whatever helps you relax, get a good night's sleep. What's mama always tell us? Get a good night's sleep and eat a decent breakfast. Don't go to Golden Corral, but I think if you eat a light breakfast, have a little bit of something on your stomach, then you're not listening to your stomach gurgle the whole time. You're not thinking about food. If you're like me, you're always thinking about your next meal. So at least if we can give you, something easy. So mama always says, eat a good breakfast and get a good night's sleep. And above all, we at Carolina School of Real Estate wish you guys success. We want you guys to do well. If nothing else, it's a selfish reason. If you're in this area, there's a really good chance that you and I could be doing a transaction one day. And I need to know that you know what you're doing. So we want you guys to be successful. We want you guys to be good. And it all starts here. It all starts here. Another email you will get from Lane after the exam is an invitation for a class survey. I would appreciate if you guys would take the time to complete that survey. It's anonymous, but Lane and I both appreciate your feedback, what we can do to grow or change to help future help future classes, help grow the school. So you can be on the lookout from that email from Lane as well. Real quick, before we have questions. Does everybody see everybody right now? Do you guys either have a gallery view or a speaker view? You guys wave at each other, say, hey. I won't be sharing my screen on test day. So this is what you guys are going to have where you can see each other. Again, I don't want you to get distracted. So do you guys see at the top right, you can minimize Zoom? Does everybody see that? Minimize Zoom. And then when you minimize, it goes down typically to one little box. Like right now, the only person I can see is Stephanie. I just went down to one screen. And now that you're minimized, you can take that screen and just kind of tuck it off to the side. Does everybody see what I'm saying? And if you can push Zoom off to the side, now you can only focus on class marker. Again, let Anika and I watch you guys. I only want you guys focusing on that exam, on your test. But this is going to be the view. So then if you need to send me a chat, you just make the screen big again. Communicate with me via chat. Breathe. You can't minimize at all. Can you make it smaller and get it out of the way? Okay, hang on with me. Hang on with me. What kind of device? Tell me what kind of device you're on. The other thing, you guys, once you're done and you see your results, you can go. You can log out of Zoom. You don't have to wait for anybody else. So when you're done, you're done. I will get an email. You will get an email. You'll see your results immediately. And you'll get an email with your report. I'll get an email as well. So you guys don't need my permission to leave. When you're done, you're done. Tara, I need you to contact me after class because of your device. So we'll have to make arrangements. Yep. What else? You guys now know what I know. Congratulations. Seriously, if I can answer any questions today or tomorrow, I'm around. You will. Please, nothing hurts me more than you guys showing up on test day saying, yeah, I never understood that. That just blows my mind. Why didn't you reach out to me? Why have we been together 2 months? Let me help you. That's why I'm here. We got a whopping 22 minutes to spare. See how much wiggle room we got in this class? We got a whopping 22 minutes to spare. So I think what I'm going to do, if you are good, you can go. We're officially over. If you want to stay around and ask questions, I'll hang on the call. But guys, we're done. The only other thing we have left to do is take a test. So good job, guys. If you want to ask some questions, I'm here. If you want to hang around and see what anybody else is asking, I'm here. Otherwise, you guys have a good day today, good day tomorrow, and I'll see you first thing Thursday morning. Thank you, guys. You guys are so nice.
Thank you, Miss Jolie.
Thank you. Michelle, are you breathing over there? Do we need to do breathing exercises together? In through the nose, out through the mouth. Doesn't that feel good? Breathing is so important. Test day Thursday. It's hard to believe, isn't it? What questions do we have? What can I answer? Can we go over dual and designated one more time? Of course. of course. So hang on. No, you won't. No, you won't, because we will get through it. I gave an exam one time in the throes of a thunderstorm. Had like 5 people lose their internet because of storm. But you know what? We got through it. I can't predict the weather. I can't predict. I can't. Yes, I agree. Where'd he go? There he is. I agree. All right, so let's talk about dual and designated. Hang on. Now I can't find you guys. Here you are. Okay. So remember, the simplest form, the most basic definition I can offer you, a dual agency, is one firm, one transaction, 2 clients. Could be 1 or 2 brokers. So in dual agency, remember our sporting analogy. Let's back up for a second. Prior to dual agency, you're the coach. You're on the field acting as the coach. You're with your client, buyer or seller, and you're giving advice. You're telling them what their next move should make. You're helping them get through the game. Once we enter into dual agency, it's the firm's role that changes. The buyer's still buying and the seller's still selling. Yes. So buyer and seller's role don't change. It's our role that changes. And when we enter into dual agency, the firm and the agents in the firm change roles and become the referee. We stop being the coach and we become the referee. Is the referee telling people what to do? Is the referee telling the quarterback what throw to play next? I sure hope not. So the firm and all the agents in the firm are straddling the wall. Buyers on one side, sellers on the other. And we all have a duty, we all have an obligation to treat the buyer and seller the same, equally and fairly. The thing that goes away in dual agency is advocacy. Since I'm treating both parties fairly and equally, I can't be an advocate of one party over the other. The thing that goes away with dual agency is advice. If your buyer looks at you and says, how much should I offer? There's no way to answer that question without harming one of the parties. If you just say offer asking price, you could be harming your buyer. If you say offer under asking price, you could be harming your seller. So in dual agency, advocacy and advice goes away. The firm and all the agents in the firm are straddling the wall. Designated dual agency is a form of dual agency. Designated dual agency is a form of dual agency. We can't do designated if we don't first have an agreement to do dual. And in designated dual agency, because it's a form, it's one firm, one transaction, 2 clients. Designated as always, one broker. I'm sorry, 2 brokers. Designated is always 2. And what's happening in designated, one agent is kicked off the wall to work exclusively with the buyer, and a different agent is kicked off the wall to work exclusively with the seller. The firm and all the other agents are still in dual. They're all still straddling the wall. The firm and all the other agents are still in dual. One agent designated to work exclusively with the buyer. different agent, designated to work exclusively with the seller. Now that they've been kicked off the wall, these two agents proceed as if there were two different companies. This agent owes exclusivity to their buyer. This agent owes exclusivity to their seller. Now, these two agents can give advice to their clients. We have to have informed written consent of both parties to do dual and designated. The firm has to have a company policy in place before they can do designated. And remember, in designated, the BIC and the PB cannot be designated opposite of each other. Let me ask you guys this, head time. Can the BIC and the PB be in dual together? Can the BIC and the PB be in dual? And the answer is yes. They can be in dual. They cannot be designated. Remember, you guys, as a provisional broker, your broker in charge is like in your back pocket, right? They're doing everything. They probably went with you on that listing appointment. They probably went with you when you met with that buyer. So by the very nature of the BIC and the PB's relationship, the BIC should know something about the other side. That's the other caveat about designated. You can't be designated if you have confidential information about the other party. So your BIC will ask you, let's say you're the listing agent, your BIC will ask you, do you know anything about my buyer that can harm them in this transaction? And then the BIC will ask the buyer's agent, do you know anything about my seller? So nobody can be designated if they have prior confidential information about the other party. And the BIC and the PB can never be designated together. Because they are not giving advice. No, they can't be designated because of the nature of their relationship. Where are you? Let me see a thumbs up. Yeah, because you're, like I said, your BIC probably what goes with you to your listing appointment, you know, talk to you about working with this buyer, that kind of thing. Question comes in, no oral agreement when it comes to dual. Shoot, sure. You can have the buyer's oral consent. Remember, the seller we put in writing. I can't do anything from the seller to put it in writing. But with oral buyer agency, you can have a consent orally to do dual. We just got to put it in writing before we're ready to present the offer. Is confidential the same as personal in this case? It might be. I mean, let's say, you know, maybe let's pretend you're the listing agent and your BIC comes to you and says, hey, do you know anything about my buyer? And you say, well, you know, we serve on the PTA together and our kids play soccer together. Could it be fair that maybe you know something about this buyer? It might not be their motive to buy or their price terms, but you may know something about them. So it might be in that case, if you know something personal about them, you may not be a good candidate because you have that edge. And remember, once you're designated, you proceed. So as if you're two different firms. So if you are designated and you have prior confidential information, you now owe it to your client to share that. And that's why the BIC should make sure that you don't know anything prior to going in. Question comes in, sellers written at all times. Yes, if they change their mind, it has to be in writing too. So remember, if the seller's going to be in writing, we're going to have consent of the seller in writing, and the buyer's going to be oral. So the seller can change their mind orally if the buyer's in oral. Okay, so if the seller says no to dual in writing, the buyer says yes to dual orally, we can go to the seller and get the seller to change their mind orally to allow the showing. Just because we have a showing, does it mean we're going to get it under contract? Unfortunately, no. But we can get an oral. If it's an oral from the buyer, then we can get an oral from the seller agreement. Got to be changed to writing before we present the offer, right? If the seller is in writing and the buyer is in writing, both parties can only change their mind in writing. So if one part, they both say no, for example, in writing, and they both want to change their mind to yes, that's fine, but we got to get that change in writing. So the question is whether or not your buyer is oral or not. Yep. Regulation X, I think it's just easier to see it. Regulation X is also known as TILA. I'm sorry, Regulation X or Regulation Z. So you got me mixed up. You want TILA or you want RESPA? X. Okay, Regulation X is RESPA. And RESPA is about the cost to close. Remember, TILA is about the cost to obtain the loan. RESPA is about the cost to close. And RESPA gives the lenders guidelines. The biggest thing that they need to understand is we got to educate the consumers. We got to provide information to the consumers about their closing costs. RESPA is the one that gives us rules on, I can't get a referral fee or kickback to or from a settlement service provider. They set limitations on like the escrow account, how much the lender can charge for the escrow account. Remember, TRID and RESPA together make up, I'm sorry, TILA and RESPA together, there we go, TILA and RESPA together make up TRID. So the whole point of TRID, TILA had their own forms, RESPA had their own forms, TRID combined them. So it's less confusing. Regulation X is RESPA, no kickbacks, referral fees. Regulation Z is TILA. And the big thing we need to know about TILA is the advertising guidelines. And TILA prohibits the lender, they say, if they say a trigger term in their ad, they have to disclose all the terms about the loan. And that's where I want to make sure. Page 409 of your book, I think it'll help you guys to look that over. What exactly is a trigger term? Because if a lender hits a trigger term in their ad, they have to disclose all of the information. And guys, remember, it's about the loan. Is the asking price about the loan? No. Are the HOA dues about the loan? No. It's only down payment, financing, interest rate, specific numbers about the loan. You see how your test likes to trick you? Just because you see a number doesn't mean it's a trigger term. You need to stop and ask yourself, is this number about the loan? You see $500 in HOA dues and your brain wants to rule it out because you saw a number, but HOA dues are not about the loan. So those trigger terms, what we just say, page 409, those trigger terms. And again, if a trigger term has been hit, it's the difference in saying, here's an example. It's the difference in saying, zero down payment versus low down payment. Which one is the trigger term? The zero. Because if they're advertising, this is the thing, you know, we all have different credit histories, right? Different credit. And they're saying if the lender can be forward enough to put a number in their ads, this is a one size fits all. They're saying anybody can get zero down payment at these terms. So if you're forward enough to put an actual number in your ad, you're saying this number applies to everybody. But the truth is we all have different credit history, different credit ratings, different credit scores. So what your zero down payment may be $1,000 down payment for me, right? So that's the difference in saying zero versus low, for example. Yep, so difference in condo and a townhome, back in unit 2, condo owners own wall to wall. Condo owners only own the space inside the unit. Townhome owners own land. They own the air rights. They own the exterior portion of the townhouse. They usually have a party wall where they get to share. The other big difference between condo and townhome is who owns the common elements in the HOA. In condo ownership, all the condo owners own the common areas as tenant in common. TIC. In townhome ownership, the HOA owns the common areas. So condo owners own the common areas as tenant in common. Townhome owners do not own common area. The HOA owns the common areas. This is fun. It's like the rapid fire over here. What else you guys got for me? Water rights. Talked about different water rights. Riparian rights are those about bodies of water without a tide. So think about your lakes, ponds, streams, creeks. Littoral rights are bodies of water with a tide. So you go down to the ocean, you got your sounds, anything that has a tide. We talked about 2 different types of riparian rights, navigable and non-navigable. So we're referring to whether or not you can get a vessel down it. If it's non-navigable, think about the creek as a party wall. The owners own to the center of that body of water. If it's navigable, the owners own to the edge of the water. Somebody else owns that water. The city, the county, the HOA, whatever. If you see a dock in a lake, it's there because the owner allows it, not because of riparian rights. Does that make sense? So if you got to Blues Creek will let you put a dock in it, but that's not because of riparian rights. Thank you, Blues Creek, for letting us put a dock in your water. Good, good, good. Yeah, how many of you went to the cram course on Saturday? I'm just curious. Oh, wow. Really good turnout. Do you guys feel like we had a good turnout? I mean, I don't know how big it was, but good. Good. I love Ann. She's great. A couple of you called her Spitfire. I think somebody called her. She is a lot of fun. Lien theory and title theory. Yeah, North Carolina is a lien theory state. We're a lien theory state. Really, the big difference in title theory and lien theory are the numbers of party, the number of parties, I guess I should say. So a lien theory state, it's only a 2-party instrument. You have the mortgagor and the mortgagee, right? The lender and the borrower. In a title theory state, it's a 3-party instrument. You have the mortgagor, the mortgagee, and then you have the third party that's a trustee, supposed to be this impartial, probably an attorney, that manages the affairs on behalf of the lender. So in the event of your default, you've already given the lender permission, the trustee permission to start the foreclosure process. So how many parties are part of the instrument is the big difference. Title theory calls it a mortgage. We call it a deed of trust. It's the same thing, and we use them both interchangeably.
And North Carolina is a lien theory.
Yes. Because we have a 3-party state. Let's see. The referral or bonus, you're talking about RESPA. So that referral or bonus for RESPA, that's to or from settlement service providers. And a settlement service provider is anybody in the transaction. Real estate agents are settlement service providers, closing attorneys, home inspectors, surveyors, lenders. We provide a service through the settlement process. And what RESPA says is we can't give or receive referral fees for recommending services. So in other words, if I recommend my buyer use this lender, the only thing the lender can do is say, thank you, Julie. They can't thank me with a donut. They can't thank me with, dinner. They can't put my name in the hat. I can't receive anything of value for recommending that service. RESPA, so an apartment tenant, for example, remember, TRID only applies when a lender's involved. Is a lender involved when you're renting an apartment? No, you're not getting a loan to rent an apartment. So does RESPA apply to leases? No, because you got to look for the lender. Is there a lender involved? Is it a cash buyer? Is it a lease? Is it a tenant? RESPA. So if you're an apartment manager of your property management, can you give and receive referral fees? Heck yeah, not unless you have a firm policy telling you otherwise. But RESPA can't regulate because TRID is a lender law. I just saw that little light bulb kicked on. I like that. I like light bulbs. TRID is a TRID is a lender law. What is the term for when an agent shops offers for clients, which is prohibited? Ew. I'm not sure the exact term. We can't disclose the terms of one offer to the offeror. We can't disclose the terms of one offer without the offeror's permission. That would be shopping offers. Like I can't, if I'm the listing agent, I can't call the other buyers and say, this is the highest thing I have on the table right now. Can you match that? So we can't shop offers. We can't pit the two against each other. The other example we gave earlier is if you're maybe you're one agent working with 2 buyers that are interested in the same property. You can't call your buyer and say, I know these guys are going to offer this much. Are you willing to go higher? We cannot disclose those terms. We can't pit them together. Mechanics lien, the 120 days. The mechanics have 120 days to file the lien after the work ends. So the work ends, you don't pay. They have 120 days to put the lien on the property. Remember, mechanics lien are specific lien that attach to the property. Mechanics are lien priority. Superior liens are paid first. All other liens are paid in the order in which they're recorded, except for the mechanics lien that's paid in the order in which the work began. So they can go retroactive. But again, they got to file that lien within 120 days. That's your 120 days from when the work ended. Anybody can file, any mechanic can file a lien, anybody that's providing labor or services. So if you bought a $200 rose bush through a landscaper and you never paid that landscaper for the $200 rose bush, could they put a lien on you? You better believe it. You better believe it, and they have 120 days to do it. Special warranty deeds. Typically in North Carolina, we see special warranty deeds in foreclosure properties. Special warranty deeds, the grantor is only promising that the deed is good. It's not encumbered during the time that they owned it. Compare a special warranty deed to a general warranty deed. The grantor in a general warranty deed is promising that the title's not encumbered from the time they own it and back. We're going back to the beginning of time. Nobody ever encumbered this property. Special warranty deed is just saying nobody encumbered it during the time that I owned it. Typically what we see in foreclosure. I think what you meant to say is North Carolina is a pure race state, which says the first one to get to the courthouse and record their deed wins. Remember, it's the Connor Act that gives us our recording rules. The Connor Act says it has to be recorded to be enforceable. The deed itself is perfectly valid if it's not recorded. The deed itself will stand up in a court of law if it's not recorded. It's Connor that comes in and says it has to be recorded. And the first one to get to the courthouse to record wins. Of course. Of course. Thank you guys. Study hard, but go to sleep Wednesday night. I'm serious. At some point, I'm telling you guys, if you think you're going to pull an all-nighter, I mean, first off, we're not in college anymore. Maybe you are, but I'm not in college anymore, right? But see, if you stay up all night studying, you're over it before the test ever begins. You've got to take a break. You've got to put the book down. Even if you want to wake up Thursday morning and look over something real quick, that's fine. But don't try to wake up at 3 o'clock in the morning and study, because when I give you that link at 9, you're already going to be done. You're going to be over it. So you've got to give yourself a break Wednesday night. Sleep. Sleeping is good. Don't drink. You can drink Thursday night. You sleep Wednesday night, you drink Thursday night. Fair enough? What else? When you think of something later, you guys know how to get me. Sheriff's deed could also be used for foreclosure. Yes, sheriff's deed. Some states may use that. Absolutely. Go get some sunshine today too. It's a nice day out. It'll be a lot nicer when my AC starts working again. As long as that's not distracting to you. Here, let me, hang on, let's practice some. Stay on with me, Tara. Let me see. Let me just throw you a link. Obviously, I'm not going to give you the class marker link because, you know. All right, so yes, good luck, everybody. All right, Tara, I just threw you a link. And it says you're not here, but I see you. You're right there. Okay, so now what happens when you click on that link? I know you can see it, but what happens when you click on that link?
Okay, I got it I can see that screen. I'm sorry, I'm horrible with technology and this
That's,
is why I
hey,
have-
I'd rather work this out now than Thursday morning. So do you have the ability to make your Zoom smaller, go away?
So my Zoom, you're about 25% of my screen and my test would be about 75.
You can't make that 20/80, 90/10?
I'm trying to go over, oh, wait, I might be able to. It's not giving me any leeway here. Hold on. Let's see. Okay, now you're gone. Hold on.
Yeah, you just went away too.
Yep. Okay, hold on. Let me see. All right, there we go. So I'll come back to you and then let me try. It really only does like a 25/75 type deal.
Do you have, you said you're on a tablet?
Yeah.
Do you have another device, like a desktop or a laptop? That's the problem we tend to have with tablets. So unfortunately, there's nothing I can do about that.
Yeah.
As long as you can see both. If on test day, because I've had problems on test day with the tablet that when they click on class marker, their Zoom goes away. So if that happens, what did I just say? Breathe and we will get through it. Right? I've been through this before. So everybody remember that. This may be new to you, but I've been through it. So if that's the case, if that's what happens, we may have to make an exception and allow you to get on your phone. So then you would be on Zoom on your phone and class marker on your tablet. So I can watch you, but I don't want to do that unless we need to. And we won't know if we need to until I give you the link. So if I give you the link and we go away, then you reach out to me in a private chat and we will get through it.
Okay, and I'll keep
will.
messing with it throughout, tonight and tomorrow and see if there's anything I missed. And I also have a friend who's pretty good with this kind of stuff who could probably help too.
Okay. And like I said, that's just a tablet problem we've had and that's the solution. So I'll say, Tara, just turn your phone back on, and yeah, and the iPad, you might have similar to Laura. So if it doesn't work, just turn your phone back on and call me and we'll get through it.
Okay.
Or send me a private message and we'll get through it.
Okay. And your number is the 687-0179.
Yep. And I'm going to put it in the chat right before we start the exam on Thursday. So you'll have it on your scratch paper. Yep.
Okay.
Yep.
Thank you so much.
Uh-huh. Absolutely. Absolutely.
Right,
So like I said, I've been doing this for about 2 years now, so it's only new to you.
Yes, like I said, me and technology just don't mix very well. So, but I'll try to get it worked out. And if not, we'll get it going. Everything will be good.
We will get through it.
All right. Thank you so much.
All right. Absolutely. Have a good day.
You too.